years. So bring your good times and your laughter too. We gon' celebrate your party with you. Come on now. Celebration. Let's all celebrate and have a good time. Celebration. We gon' celebrate and have a good time. It's time to come together. It's up to you. What's your pleasure? Everyone around the world, come on!
In the name of the Father, and of the Son, and of the Holy Ghost. Amen. In Jesus' mighty name we pray. Father Almighty God, we thank Thee for this gathering. Father, we pray Thee, Lord, anyhow we have offended Thee, Lord, have mercy upon us. Father, we pray, be with us and take charge in every activity we will do here in this program, so that in the end, this program will be a success. Thank you, O Lord, for hearing our prayers. For in Jesus' mighty name we pray. Amen.
Thank you very much, Mr. Anselm Obareze. To honor Nigeria, which is one of the main purposes of this event, please may we rise for the national anthem.
Nigeria, we hail thee, our own dear native land. Though tribes of their differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace all battle honored, and this we count as gain. To hand unto our children a banner without stain. O God of all creation, grant this our one request. Help us to build our nation where no man is oppressed, and so with peace and plenty Nigeria may be blessed.
Learned senior advocates, legal practitioners here present, men of the press, captains of industry, and all well-meaning Nigerians watching this program from all over the world. The program is streaming live, and we're getting views from all over the world. We welcome you very much to the Rule of Law Development Foundation's webinar series number 14. This event is hosted in celebration of the 45th anniversary of the call to the Nigerian Bar of Mr. J.B. DAUDU, Senior Advocate of Nigeria, and in celebration of his conferment, 30 years of his conferment to the rank of Senior Advocate of Nigeria. Please let's give it a round of applause. As the selfless leader that our leader is, Mr. J.B. DAUDU SCN, he has decided to celebrate this event, even though it is marking a milestone in his own personal life. He's dedicated it to discussing the progress of Nigeria. To that end, he's coined a topic, addressing the problems of modern-day Nigeria through constitutional amendments, my input as it relates to the ongoing process of constitutional amendments. We welcome everybody here present and want to specially recognize dignitaries here present. We want to recognize especially the presence of the Executive Governor of Kogi State, Alhaji Usman Ododo, who is here, represented by the Attorney General and Commissioner for Justice, M.Y. Abdullahi, Senior Advocate of Nigeria. Please let's give him a round of applause. We want to also recognize other senior advocates here present. We want to recognize the presence of Mr. D.C. Nwelum, Senior Advocate of Nigeria. Please let's give him a round of applause. Thank you very much for coming, sir. We want to recognize the presence of Mr. Adeola Adedipe, Senior Advocate of Nigeria as well. We want to recognize the presence of Mr. Paul DAUDU, Senior Advocate of Nigeria. We have special guests from the Buhari branch. We have in our presence the elected chairman, Nigeria Bar Association Buhari branch, Mr. E.I. Onwude. Please let's give him a round of applause. Accompanying him is his secretary, Buhari branch, Mr. Paul Ibobi. Please let's give him a round of applause. We also have the vice chairman, Anayasi Agnes Fachi Omuya. Please let's give a round of applause. Give a round of applause. We also have special guests who are classmates to the celebrants today. We want to recognize their presence. We have Mr. Mohammed Abdul Sule. Please let's give them a round of applause. They are here to celebrate with their classmates from secondary school. Dr. J. Akimbu, Mr. Kasimu Bayero, Mr. Jide Williams, Mr. Bokno T.A. We also have eminent legal practitioners here present. We recognize the presence of Madam Ozioma Izora Esquire from Bayes University. You're welcome, ma. We also have Mr. Anslem Obareze, partner JB DAUDU and Co. We welcome you specially to the event. Thank you very much, everybody. We would have a welcome address. We will now have the welcome address from Mr. Paul DAUDU, Senior Advocate of Nigeria.
Well, this is an expertise order served on me by the MC, but God forbid the day a lawyer will not have anything to say, especially on an occasion like this. As one of the trustees of the Rule of Law Development Foundation, my job is to welcome all our distinguished guests, allow me to rest on the existing protocol and recognize, as he's walking in, Mr. A.T. Kende, Senior Advocate of Nigeria. Let's give him a round of applause. You're welcome, sir. You're very much welcome, Leonard Sik. My job here is simple. It's simple because we have a well-researched, thorough paper. And I know all of us are itching to hear from the coordinator of the Rule of Law Foundation. We may not be aware, but there is an existing constitutional reform exercise going on. The National Assembly has been having seminars and geopolitical workshops. I think it started some months ago and it's still ongoing. So at least this paper, I'm sure, will kickstart that conversation so that as citizens we are well armed with information, so that in our various geopolitical zones we can contribute to the ongoing discussion. So on behalf of the Rule of Law Foundation, I welcome everybody. I urge us to listen attentively to the paper that will be presented, and I'm sure after this we'll have actionable points that we can take to our various places and reform Nigeria. So thank you very much, and God bless you for the opportunity. I'm grateful.
Thank you very much. Mr. Paul DAUDU is a senior partner at the firm of JB DAUDU and Co. Thank you very much. Next, we would want to call on the Governor of Kogi State, represented ably by the Attorney General of Kogi State, Mr. M.Y. Abdullahi SAN, to declare the event open and give us the goodwill message of the Governor. Thank you very much, sir.
Crave the indulgence to rely on the protocol already established. First and foremost, the Kogi State government congratulate her son of inestimable value. A legal juggernaut of high repute on the occasion of the celebration of his 45th anniversary of his call to the Nigerian bar and 30th anniversary of his conferment with the rank of Senior Advocate of Nigeria. Learned Silk, you have made the state proud, and we are solidly behind you and wish you well in all endeavors. To the topic under discussion, which is addressing the problems of modern-day Nigeria through constitutional amendment, it is imperative to stress that the importance of constitutional amendment in Nigeria cannot be overemphasized, as some of the provisions of the Constitution are no longer in tune with international best practices. Amendment of the 1999 Constitution of the Federal Republic of Nigeria is therefore crucial for the following reasons. 1, to promote the rule of law by strengthening the independence of the judiciary, enhancing the protection of human rights and access to justice. 2, to strengthening federalism in Nigeria. State governments should be made more independent by proper devolution of powers. More power should be devolved to state governments for rapid development across the country. For example, both federal and state governments should be allowed to legislate on issues that borders on mining and so on. Thirdly, to address provisions in the Constitution that are capable of causing confusion or multiple interpretations. For example, who legislates on items not contained in either the exclusive or concurrent legislative list. Fourthly, to bring the Constitution at par with changing times in order to align same with international best practices. In conclusion, an amendment of the Constitution is vital as it ensures that the Constitution is a reflection of the aspiration as well as the needs of the citizens of the country for an efficient promotion of good governance and national development. Once again, we, the people of Kogi State, congratulate the Learned Silk, J.B. DAUDU, Senior Advocate of Nigeria, for this milestone of celebrating greatness, success, and outstanding impact in the legal provision in Nigeria and beyond. I have the privilege, consent, and authority of His Excellency, the Governor of Kogi State, to declare this event open. Thank you very much.
Thank you very much, the Governor of Kogi State, ably represented by the Attorney General and Commissioner for Justice, M.Y. Abdullahi SAN. Thank you very much, sir. We want to welcome and recognize especially the presence of Learned Senior Advocate Mr. A.T. Kehinde, Senior Advocate of Nigeria, who walked in while the event was ongoing. Thank you very much. We want to also welcome Mr. Audu Anuga, Senior Advocate of Nigeria, who walked in. Thank you very much. Before we receive the lead paper presentation, we want to sorry, my sincere apologies. I want to file a motion for forgiveness. My eyes, these glasses failed me. Please, may I welcome His Lordship, Honorable Justice Alaba Ajileye. Thank you very much for coming. We welcome you very humbly, sir. Thank you very much for coming. We want to call on Madam Ozioma Izora for her special presentation in honor of the Senior Advocate of Nigeria, Mr. J.B. DAUDU, SAN.
Sorry, I didn't know it had got to me yet. Good morning, everyone. I stand on existing protocol. In my other life, I'm a writer, and in this event, I thought I'd put something together to express my view, our view, collective view of J.B. Daudu, who he is. I call this Ode to Greatness. Epithets abound to eulogize the man J.B. Daudu, to epitomize his self-effacing, big-hearted, gargantuan personality. But alas, all fall short. None encompasses this colossus, from whose ever-energizing pool of deep knowledge, legal minds are privileged to quench their thirst time and time again. As the president of Nigerian Bar Association, he bequeathed the nation a proud egalitarian bar. Many works from deeply researched and thought-provoking conferences remain in evidence. A habit he sustains to date through personal enterprise. The purity of JB's heart is easily gauged by the choice of celebrating the milestones of his career, intuitively agonizing for the good of his country. Through the Rule of Law Development Foundation, he searches out and ruminates on solutions to the plight of the oft-ignored boy child, while not relenting on the fate of all and sundry. Annually updating developments in criminal law, human rights, and good governance, JB's exertions for this nation unparalleled makes him an institution. The powers that be bow to his quiet strength. The learned take comfort in his enduring legacies. His smile, both childlike and Christ-like, connects with souls in search of succor, drawing them in, reinvigorating them. To mark the 45th anniversary of his call to the Temple of Justice and 30 years in the inner bar, it is opportune to raise a cup to JB's exemplary and continuing leadership in all matters, legal and fitting. I end this in gratitude. This was just written 16 July when I heard he was going to celebrate this. So forgive me if I didn't go deep enough, but I think, roughly speaking, everybody can identify J.B. Daudu from this short piece. Thank you for listening.
Another round of applause for her, please. Standing on existing protocol, I would like to recognize the presence of A.A. Ibrahim, SAN. You're welcome, sir. We also have with us Dr. Muritala Abdul Rashid, SAN. We have Mr. Ido, one of the celebrants' classmates in our midst. You are very welcome, sir. A round of applause, please. Today, we are gathered to celebrate a legal titan, a rare luminary whose brilliance illuminates the courtroom, a man whose life is a masterclass in excellence, humility, and service. Due to time constraints, I'll be listing a few of his numerous achievements. He was called to the Nigerian bar in 1980 after earning his law degree from Ahmadu Bello University, Zaria. He attained the rank of Senior Advocate of Nigeria in 1995, becoming one of the youngest to do so. He served as President of the Nigerian Bar Association from 2010 to 2012, a tenure marked by bold reforms and advocacy for the observance of the rule of law. His leadership helped position the Nigerian Bar Association as a watchdog for democracy, challenging unconstitutional actions and promoting civic rights. JB Daudu SAN is the principal partner of JB Daudu & Co., and a life bencher with decades of exceptional service in the legal profession. In addition to his remarkable career as a lawyer, he has contributed to legal scholarship through lectures, articles, public commentary, conferences, and webinars hosted under the Rule of Law Development Foundation. He's also known for his mentorship and emotional presence in the lives of colleagues and mentees. In Nigeria's legal history, certain names are written in gold. One of such is JB Daudu SAN, whose 30-year sojourn at the prestigious Inner Bar is worthy of celebration, admiration, and gratitude. At this point, with a standing ovation, can we give a resounding applause for the man of the hour, as we not just celebrate his 30 years of silk, we celebrate a life of purpose, a life of service, and a life of profound influence. A round of applause, please. Can we welcome the celebrants of the day, JB Daudu SAN. Welcome, sir.
Good morning, everybody. I take it now that the ball is in my court and that I can proceed from here. I think those who are familiar with academics will know that at a point in time of a career of an academician, he delivers what they call an inaugural lecture. So in this part of our own sojourn, I take this as my own inaugural lecture. So you will bear with me and accommodate me because of the events. I must start by thanking everybody who either physically, online, before now has called on me to congratulate me and to thank God in unison with myself and the family on this auspicious occasion. When I was called to the bar, and I would tell this story. While we were celebrating the first year at the bar, second year, third year, a colleague and classmate of mine, callmate, used to have this argument every year. the late Oluibitoye, Esquire of Kaduna. We had this argument about what the date was. According to him, it took place, we were called to bar on the 18th. And I said, no, it's 19th. And we tabled it to all our colleagues at that time in Kaduna, Ekanem and the rest of them. And they said, well, they don't really remember. In those days, we were only about 500 that were called to the bar. So we were called to the bar at the same time. There was no morning or afternoon. All of us were called. For indeed, 499 of us that were called to the bar. So we reached an amicable solution when it was brought to our attention that the call may have been on the 18th. Nobody really remembered because of celebration that took place after and the rest. But that we enrolled in the Supreme Court on the 19th. So on the legal documents of date of call to bar, it is the enrollment date that featured, which is what stuck in my own head, that the date of call to bar is the 19th. But whichever one it is an opportunity to give thanks to God. And so that's why I said, okay, let me put one leg on the 18th today, and then another leg on the 19th tomorrow by doing the church thanksgiving or the mass thanking God. So that explains why we have today. Today marks exactly the 45th year of the call to bar. Then as to the one of the 30 years of Inaba, it was actually announced I think between the 18th and 24th of February 1995. And I was then doing, my detractors said they gave me SAN because I joined in convicting Ken Saro-Wiwa, that I prosecuted the case. But actually the case had not started then. And if anybody knows the procedure for applying for SIL, it is settled long before. And actually, my first application was in 1992. No, I was asked to apply. In those days, you dare not, as a young man, put up your application. You are invited by the Chief Justice of Nigeria to apply. And so they said, well, you have washed your hands very well. You are qualified to eat with elders now. So in 1992, I was actually invited to apply, and they sent the message through a hierarchy. First to the presiding justice of the Court of Appeal, who calls your divisional administrator of your judicial division and say, this young man, tell him he can put up an application. Because then the rank of senior advocate was given only to seven qualified persons around the country. And so there was no room for young people. So be a young man to qualify, like Olanipe Kunz, the Shofundes, the Aomolos. You had to be the best among your peers. So there was the Honorable Justice Akas, who was then the administrative judge of the Zaria Judicial Division, where I practiced, and which cases from Zaria I used for my application, and which period was no longer 10 years, was not 10 years like today, that your cases will last. Your cases lapse every 3 years. And you had to have a minimum of 6 accomplished Supreme Court cases, 4 in the Court of Appeal, 6 Supreme Court. But by the grace of God, when I was applying, I had 12 Supreme Court cases within 3 years, 60 Court of Appeal cases, and then hundreds of High Court cases. They were wondering if I had any other work to do other than going to court. So my administrative judge called me in 1992 and said, please apply. I've been directed to ask you to apply. I said, my Lord, I am only 32 years old. I will not apply. I'm not mature enough to wear that rank. He said, I've told you what they told me to do. So I omitted to apply that year. Incidentally, in that year, though the complement was 7, they gave only 5. They gave only 5. In 1993, when I now thought my teeth was now sharp, I can apply. The house was full. And that was when they gave the likes of, if I can remember, 1993, the name of this Ijebu man who, Professor Adesoya. Professor Adesoya SAN, heavy pack. And so the shortlist came to 9. And they said, well, this 3-year rule, this is a young man, myself and the late Laddie Williams, that we will not increase the number to be setting bad precedent. But we will consider them in 1994 if the Lord tarries. So that is how, I said, in any case, one of them told me, we asked you to apply last year. You refused. So you can see what happens when you don't listen to elders. But just be patient. I thanked him. He's still alive today, retired Chief Justice of Nigeria. And I went back to the drawing board and continued work. 1994, there was no conferment done. Why? They said, no, don't worry that the Attorney General has been insulting us up and down and that he's not a senior advocate. But the rule at that time was that upon being appointed as Attorney General of the Federation, the Privileges Committee must summon a meeting and confer you with the rank. So Dr. Nagorua was then the Attorney General. There's a partnership between NADECO and the government of Abacha. But they fell out. And upon falling out, the Supreme Court felt that, especially with this issue of Abiola raging and the rest of them, the Supreme Court, the Privileges Committee, did not call for a meeting. And if they don't call for a meeting, you cannot be appointed. So we all suffered in 1994. Somehow in 1995, around the same, before January or so, the President Abacha, the military president or the military head of state, removed Dr. Nagorua, who later became SAN in his own right, during the era of Chief Justice Aloma. I think it was during Goodluck Jonathan. And they now called for the meeting. Said, where were those 2 people that we stepped down in 1993? Those days we used this phone, not 9-Not. If any of you remember not 9-Not, a satellite local phone. And so I was doing my case in Port Harcourt when somebody called not 9-Not. It was ringing. So I took permission from Chief Philip Omadi SAN, who was leading me. And I went outside and picked the call. He said, don't say anything, don't say anything. No. Because anybody who has applied for SAN knows that it's a foolhardy thing not to have an insider in the committee who will tell you whether you have made it or you have crashed. So they said, don't say anything, no, don't say anything. No. I didn't say anything. I went back and tried to pretend as much as possible that it's a very difficult thing to do. Until I survived the session, I wasn't beaming or letting anything out. Then that evening, I went to the house of my very good friend and colleague who is also celebrating 45 years today, Mr. Isi Okala in Port Harcourt, and he had dinner for me. And then I told him that this thing has finally happened, but I didn't tell him. Incidentally, we were in court together with him on that day. So I told him that, and we had dinner. Then I said, I have to return back to the governor's lodge where we were quartered and join everybody to listen. Because in those days, the only way you could hear that an appointment had been made was on network news, 9 o'clock. So at about 10 to 9, I got into a common sitting room. Chief Umadi was there. He said, everybody keep quiet. They will announce senior advocates. So I sat and joined them. I didn't say a word. So they said 14 senior advocates, 13 legal practitioners conferred with the rank of senior advocates. Say, keep quiet, let's listen. So they went through the 14, and I was the last, being the youngest at the back then. So they looked around. They said, which DAUDU is that? They said, is it your boat? I said, how many DAUDUs are in Nigeria? Sir, it is me. The man was very upset. Not that he was not that, but that I was in the same house with him, eat with him every day, and I never mentioned to him that was a candidate to be conferred with the rank of senior advocate. Indeed, a lot of people came to lobby him. We can say these things now because of the 30-year-old rule. A lot of people came to lobby him, I won't mention their names, whom we were called together, asking him to please put in a good word about them to Sir Glenn, his bosom friend. Mr. Clement, blessed memory. So he said, I've seen all these things, and I didn't mention. I said, sir, they said we shouldn't lobby. So that's why he said, you knew what you were doing all along. Well, congratulations. And then I will at least end this part by saying, at that point, we had siren rushed into the car. The military administrator of the state, then Colonel DAUDU, came in and ordered everybody to proceed to government house, and there we partied till the morning. So it's just before the paper starts, on a light note, to let us know the history of both events and how it came about. So on this note, I will go into we can't go through all what has happened between 45 years and 30 years. On another occasion, the Lord tarries and spares our lives, we will gather again to launch JB DAUDU SA through the cases. Mr. DDG SAN and his team, I'm sure he's very angry at me. I sent him to court this morning. And he tried as much as possible to wriggle out. But I said, don't worry, your reward. Go and let us save this client from the situation he's in. So he is chairing the team that are working on it. At the Lord spares our lives, we will get to launch what will be like a compendium of the few modest cases that one has done within the 45 years period. So when you are coming on that date, please come with your checkbook. Or instruments to make transfer. Don't worry, we use a small place like this. We will look for a bigger place, and everybody will be required to make some token sacrifice. So let's go to the paper. The problems of Nigeria, before I come to reading specific aspects of it, the problems of Nigeria is of historic antiquity. That means we have come a long way. In some instances, let us take it from the annexation of Lagos, which is in 1864. So, and then down to 1900, then 1914, the amalgamation of the North and South. All the constitutions that came in, Clifford, 26, I mixed them up, oh, please don't be angry. Littleton, Macpherson, and then the Independence Constitution. We have gone through what modern people, young people, Gen Z call a lot. Well, if we were moving in the right direction, that a lot would have been beneficial. But we at times, we turn the vehicle around and head backwards. At times we knock the engine and come down and carry the vehicle on our heads, try to carry it. But it doesn't answer us. At times we are forgetting the vehicle now and we are running around in circles. But God save us. Nigeria is still our home. We have nowhere to go. And we must always look for measures and how to improve our lot. Now, let's understand why we have constitutional amendment. We do have constitutional amendment because we have a constitution. And we started with, let us say that we started with the Independence Constitution in 1960, when we just received the baton of freedom from the British, the colonial government. And on that very pleasant day, mature politicians gathered, the Awolowos were there, the Ziks were there, the Saldana and his team were there, and Mr. Didiji is here. I just talked about him. I hope he's not too happy with me. Okay. Now, on that auspicious day, we received the baton of independence and continued from there. 5 or 6 years later, the military struck. And we moved from a Westminster export model constitution to, and understand this point, because regardless of what, I'll ensure that everybody gets a copy of this paper. That will explain our present mentality. Regardless of how people say they want a change in the manner of governance, we'll get to that point. 6 years later, the military for the first time in Nigeria took over the reins of power. Now, if you understand how the military functions, don't worry whether it was Irosi that was there or it went to any other part of the country. It would have still been the same measure of trying to unitarize the government of the country because of the one-line command structure of the military. The military does not know how to rule, being military men in that diplomatic panel manner. It was learning from the mistakes of Irosi that they played politics with the issue of state creation, trying to decentralize and devolve powers to units. So you must understand the mentality and the psychology of the military. And then the Civil War came in, and they fought, though they created states to diffuse tension, and I will explain in due course. They created one state for what I will call, and pardon me, the core East, that is Indigo, East Central State, and took out Cross River and Rivers. It was, I cannot say not in good faith, but it was done to diffuse the strength of the Eastern region by giving autonomy and powers to minorities within that zone. So they still ran and fought the war in a unitary manner, but state creations, which had been advocated since the 1957 Willings Commission, that's when the Cross River Obuja got their own state. So the point I'm bringing before I stray and digress too much is the fact that we exited the Civil War, went into General Mohammed's administration as essentially a unitary government. Never mind the Supreme Military Council consisting of governors of state. This real power laid in the hands of the Commander-in-Chief. Please note this point. In the Commander-in-Chief of the Nigerian Armed Forces, who is known by many names today: the President of the Federal Republic of Nigeria, Head of State, or by any other name called, everybody exists and exercises power at his pleasure. So let's not deceive ourselves. And that informed the trajectory in 1979 when there was a donation or transfer of power from the military to civilians. So President Shagari emerged, and he was elected as president, and then not this one, Commander-in-Chief of the Armed Forces. Every other person from that point in time was beholden to President Shehu Shagari. And it went on. There was an election, but the military was not used to being out of power, and they came in back again in December 31st, 1983. Incidentally, the coup caught up with me in Abonima in Rivers State. I went to enjoy, as a bachelor, Christmas there. And so the military continued in the reins of power, entrenching that centralized and unitary approach to power between 1993 and 1999, which, little wonder, produced the first civilian president under the 1999 Constitution, which is now being sought, or which has now been subjected to several alterations. We are 5 in number. And we are 5 in number. So the alterations that took place on the basis of the existence of the same unitary and centralized approach to power. And we have had how many presidents after that? President Obasanjo, President Yaradua, Goodluck, President Buhari, and the great man Asiwaju Bola Tinubu. Now, whatever anybody may try to tell you, it is entrenched and ingrained in the psyche of Nigerians and the leadership, that there must always be a big strong man up from whom power will devolve to downwards. Call him the president, call him leader, call him by whatever name you call him. It is actually his will that will be fulfilled. So when you now, a few people now say, oh, this constitution is not working because it was not given to us by the people. It was not given to us by the representatives of the people, but it was given to us by the military. I say it is a lie. We are deceiving ourselves. Now, when the military were in power for 28 years, they paid salaries. They gave COOs to people. They carried out projects. They gave contracts out. People became millionaires. They impoverished some people. They seized properties. Now, when they did all this, nobody complained and said those things that they donated and they gave to Nigeria by virtue of what Kelsen will call pure theory of the law, that they were illegal and unconstitutional. They chopped and ate and fed fat under the military. When they now bequeathed a constitution to us, it is now being said by eminent groups like the Patriots that the constitution is defective merely because it was not, what the use of the word constitutional lawyers would know it, orthogonous. That means it is not grassroots oriented. Now, at this point in time, whether or not it is autochthonous, it is grassroots, it is by the representatives of the people, is neither here nor there. And it is my own theory and thesis that it is not how the Constitution was made that commands its obedience. It is whether the people are willing to submit to that Constitution. And in our own situation here, because of ethnicity, religion, personal interest, 70%, we are usually minded to run any system that has been put down for us and run it aground. So nobody, especially those who did not believe that the military will hand over power in 1999, who missed the chance to be senators, governors, representatives, and allowed, and I say it with deference and respect, people who trusted and believed, or some people say, who are the boys of the military, those who went into power. So the first 11 and second 11 was virtually eliminated. What was left then was the mosquito team, and I say this with respect. Let Ashioju not be annoyed with me that I say those people who became senators at that time were mosquito. But the point still remains that it has become a power tussle between those who are within, enjoying the transfer of power from the military, and those who missed out on boarding the bus when they should. And you know, in Nigeria, whether you like it or not, it is winner take all. And when winner takes all, it is his political family that will inherit it. Immediately, those people who refused to board the bus at that time, and some of us didn't board it, but we had other avenues of engaging the system. But those who refused to board the bus are classed as opposition. And because they are opposition, their work is consistently always to try and see how they can get power from the people who are running the. So the issue of constitutional amendment, whether you like it or not, is one of the measures being used by those outside to try and see if they can force a transfer of power or a change of power. Because when I'm able to persuade people, look at the people who came out as patriots, although they've been beneficiaries of various governments over the years. But there are people who today will not mind, because all our presidents must be over 70 years. Before you are qualified to be president in Nigeria, youth don't bother. Unless you gather all of them in one place and but they won't call them. But the earliest age you can qualify for president in Nigeria is 72. And by that time, sir, you are still a spring chicken. So even people like me now, no, for me, I will only be chairman, president of the youth wing. Youth wing of the party. So these Gen Zs and the rest of them that think that they will hand power over to you, you are just you are joking. You have not read there. So constitutional alteration, constitution amendment is a means, in my own humble theory, for opposition to take back power. Is a form of coup d'etat, so that if the level field, if the field is now level, and they say bring another constitution, then maybe if you see part of the things they will think out with this latest Patriots exploit is not INEC, because anybody who owns INEC owns the trajectory to the highest office. Whether or not you like it, that is the truth. And the only people in Nigeria that suffer are people who fail to see the reality and fail to address the truth and know their position in the scheme of power. So long as you know your position, then you can engage the system and get to where you want to go to. So this is a background to it, a background to the paper I'm about to present, a background to the fact that the alteration of constitution is the continuation of the power tussle in a civilized way between contenders for political power in Nigeria. It is nothing more than that. And so, in trying to do so, people bring suggestions that are wise, that are beneficial, that are practical. At the same time, they bring suggestions that are plainly self-serving, that suggestions that are downright stupid. I ask for pardon for the word. Suggestions that you will be wondering, why would anybody make such a suggestion? Is it to promote anarchy? Or is it to cause a complete destruction of the system? So I will run through the paper that you best understand the paper from, because the paper will now deal with practical issues. But I will take the preliminary part, identify those areas that are relevant to us in this room that are being proposed for constitutional amendment, and say what my position is, and at the end of the day conclude in one way or the other, leave you to draw the conclusions. Now, I will take the introduction because being a paper, it's at page 1. And I said, governance in Nigeria since our independence has operated under successive constitutional frameworks aimed at fostering unity, good governance, and infrastructural development. However, the 1999 Constitution as amended continues to reflect a unitary and over-centralized structure that limits innovation, accountability, and regional development. It is increasingly evident that some of Nigeria's major challenges, such as insecurity, bad individual and communal attitudes, economic underdevelopment, administrative inefficiency, and political tension, are rooted in leadership vacuum, not resolvable by constitutional amendment. For instance, how can the endemic corruption afflicting both leaders and followers, even market women, everybody who wants to make money in Nigeria, the keke nape, everybody has his own approach to making the extra money. So how can this attitude of corruption be redressed by constitutional amendment? No. The seeming structural imbalances entrenched in the Constitution, and listen to this point well, are there, have been planted there deliberately because of the selfish agenda promoted through subterranean means. The word subterranean was used first in the Nigerian political lexicon in 1975. There was a conference at Ahmadu Bello University. Just digress so that you understand it. And it caused a great deal of hula baloo. They were debating the 1979 Constitution. And it was done in the hall of the Institute of Administration. And all the juggernauts of those days, 50 years ago, from Chief Williams, Professor Billy Dogley, Jide, can you help me with the name of Mama Tahir? Ibrahim Tahir. Yeah. My late father, they were all in the hall debating, as we are doing now, the progress of Nigeria. And then Malam now threw in an accusation that some people, the military, and who was the military then? I think, no, it was 76, so Obasanjo was then in power. That he used soft subterranean maneuvers to try and influence the 50 wise men. In those days, there was still probity. Now, the word subterranean, as a 16-year-old, was new, but the elders took umbrage, meaning that he was trying to, Obasanjo was trying to influence the 50 wise men before going to the ASTU, certain issues in the Constitution. Now, I mentioned this, pausing at this point, to show you that it is always the will, I think it's the Austinian principles of jurisprudence, the command of the leader that represents the law. So there was bedlam, there was uproar. So I've used the word subterranean here to show that till today, they still use subterranean and indeed very crude means to ensure that their own way prevails. So going back, these imbalances can be adjusted by realistic and constitutional amendments, not fancy ones. As the National Assembly and other public-spirited individuals and groups embark on another round of constitutional review, I took part in one when I was president of the NBA, one of the few times that I had the pleasure of flying private jet, because I was moved from one point to the other to present the position of the altruistic group who are representing both the judiciary. So this, you can't say everything that you know. So it's all a matter of interests. That's the point I'm making. So it is imperative to seize this opportunity to make far-reaching and transformative suggestions to the amendments that will address the root causes of Nigeria's dysfunction. Now, I have tried to define the word constitution at page 2. It is my own handcrafted constitution. You may clap for me. I said a constitution such as the 1999 Nigerian Constitution is the basic and indeed fundamental document of manual, contents of which are agreed upon by the people or their representatives, designed for the administration and management of the Federal Republic of Nigeria, by ensuring that the functions and duties of the three arms of government, in bracket, executive, legislature, and judiciary, the devolution of powers to the federal, state, and local governments, and their key agencies and personnel are identified, defined, and specified in clear words in the said document. So that's my own view of what a constitution is, particularly the 1999 Constitution. So I now interrogated the issue. Is the Constitution a contractual document, or is it a political document? But the parties to the contractual document is the government on one hand and the people. And those who have looked at the 1999 Constitution will look at it from the angle of Section 6, which is always a definition between the government and the people. A constitution is a documentary embodiment of the social compact, and those who did government and some element of economics and jurisprudence will remember the social compact or social contract. And I have in the footnotes put down the views of Thomas Hobbes, John Locke, and Jean-Jacques Rousseau. So at your spare time, you may look at their own approach to the social compact or contract. And here, to emphasize on the contractual, I take the view that the Constitution is a contract and not just a mere political document. It is only needed to emphasize on the contractual nature of the Constitution and to highlight the points that, as with all contracts, and government officials will know this, a variety of circumstances and emerging situations may from time to time necessitate amendments, reviews, and adjustments. They call it variation. You vary contracts. It is with this latter process, that is constitutional amendments, that is relates to the Nigerian Constitution, that this article, this write-up is concerned. It has been identified in the concept note to this webinar, and by extension to this paper, that there have been at least 5 alterations, and I've run through it there to say the 5 alterations took place in 2011, 2017, and 2023. And that the late, may his soul rest in peace, I've always referred to him as General Muhammadu Buhari, President of the Federal Republic of Nigeria from 2015 to 2023, that he passed 16 constitutional alterations into law. Now we are engaged in another exercise, and I call it another rash cycle of amendments. And I think that if we do not approach it very well, that we'll miss the danger signs that are very apparent to us. So before embarking on identifying the amendments and the drawbacks, I must draw attention to the fact that even though the amendments are political in nature, and is seen by politicians as their amusement park, especially those in the National Assembly, whose duty under the Constitution is to midwife the said amendments, It is a very onerous and indeed cumbersome procedure, since it requires in subsections 2 and 3 of section 9 the activation and fulfillment of the following steps. 1. Every amendment must be supported by at least 2/3 majority of all the members in each house of the National Assembly, Senate, and House of Rep, while the amendment must also be approved by resolution of the houses of assemblies of not less than 2/3 of all the states. So you know how difficult it is, or it is going to be. It is not necessary to restate all or even avert at this stage to some of the alterations carried out within the ambit of the 1st to 5th alteration, but I promise to refer to them as time goes on, where necessary. Now, in interrogating this topic, I have posed certain questions on page 3, and I'll run through them. That it is to test the proposed amendments with the following: whether the major amendments can be identified, are the amendments relevant or beneficial to the progress of the Nigerian state? 3, do they proceed from altruistic intentions, or are they merely self-serving to cushion political interests and ambitions? D, whether the amendments passed and contemplated have withstood the test of time and constitutional durability. 5, will the proposed amendments, such as the creation, and note this one, of 46 additional states, or the restructuring of the judiciary, not render the system unwieldy and thereby add unreasonably to the cost of governance? 6, are the amendments necessary or important to our present state of political growth? 7, will the proposed amendments tackle the biggest cankerworm in Nigeria, or cankerworms, to wit, corruption and insecurity? Have the people of Nigeria keyed into the proposed amendments? I can just answer that one to you. When you ask people, are you following constitutional amendment, they will tell you, will it put food on my table? So that's how they get away with blue murder, and people, because of apathy by the people. And last but not the least, whether the entire exercise is not a failed enterprise. Now, I do not intend, and I did not in the paper, apply these questions to any proposed amendment that was considered. What I did simply, like lawyers who argue applications for stay of execution or no case submission, you don't have to apply or all the factors, all the principles. You can just take one. If it's an issue of jurisdiction, if it's special circumstances, just take one and apply to the subject of consideration. And if you are satisfied and it solves the matter, you move to the next stage. So what I've done is, when considering those points, I just picked one of these, applied it, and if I'm satisfied that it is a good amendment, I say so. If it is not, I also join in raising alarm bells. So the areas we will consider, and briefly too, are 1, judiciary bills. It is being sought to alter the constitution so as to enhance judicial independence and accountability, efficiency and access, election disputes reforms. Some people have come to say there should be religious, ecclesiastical courts and customary courts. It will come to balance the existence of Sharia courts in certain jurisdictions. Embellishment, you hear my views on it in due course. Establishment of at the level of the Court of Appeal, please, that may not be what was now expressed in the body of the amendment. I think they were level of the Court of Appeal of states. tribunals and oversight bodies, and the welfare and pension rights of judicial officers. The far-reaching suggestions were made as to those. Then, the elephant in the room, creation of 46 additional states. 3, local government autonomy. 4, but erroneously marked as 6. 4, state police and security architecture. And 5, other constitutional alteration proposals. The foregoing will be sufficient for our interrogation, and it will be safe to say that since charity begins alone, I will begin with all the proposals relating to the courts and justice delivery system. And after setting each one out, I will proceed to consider their reasonability and viability before suggesting the appropriate solution or reactions which the National Assembly should adopt in relation to these bills. So, constitutional amendments pertaining to the judiciary. Now, that paragraph just has been repeated elsewhere. And the first one we will deal with at page 5 is the position of the governorship election petition appeals terminating at the Court of Appeal. Now, prior to the 2010 constitutional amendment, I might note one absurd thing is that the Constitution was amended to remove finality from the Court of Appeal in 2010. And in 2023, people are asking and suggesting that we should go back to that level for very unrealistic reasons. But let me not let the cat out of the bag yet. Now, before the alteration, the provision of Section 2463 of the 1999 Constitution read, the decisions of the Court of Appeal in respect of appeals arising from the governorship and legislative election tribunals shall be final. This provision denied litigants access to the second level of appeal on gubernatorial disputes, an arrangement that was severely criticized and clearly unworkable because of the conflicting decisions rendered by the divisions of the Court of Appeal on identical issues. And these conflicting decisions has been there for a long time. Since 1991, when the first set of governors came under this mixture between military rule and civilian rule under the President Ibrahim Babangida. This situation brought a lot of distrust in the Court of Appeal and led to an uproar, clamor for the return of the post-1979 era, where governorship appeal terminated at the Supreme Court. Now, I have shown the cases between 1979 and 2003 at the reference point on page 6. Cases of Onoha against Okafo, Unongo against Aku, Kadi against La, Obi against Tumbakwe, Mwabodo against Ono, Omoborewa against Ajashi, against Oluloyo, Toti against Tukbabi, and Ujuku against Umudiwe, even though there's some of them senatorial cases. But you would see that in those days the Supreme Court had the final say, and there was sanity in the system. But in those days, I said, because of the force of the doctrine of judicial precedence and the principles of judicial accountability flowing therefrom, and that's why we pick issues with the present Supreme Court nowadays. Because today they decide one thing, tomorrow they decide another thing. And when you ask them, they say we are the Supreme Court and we are entitled to change our mind. Precedent binds the Supreme Court too. And there is a remarkable procedure for them to change their minds, sitting as 7 justices and being requested to do so, and not for them to just depart on their own as they wish. no court is uncontrollable. They will just be scraping the ground upon which they stand on. Now, the first alteration of the 1999 Constitution repealed Section 2463 and amended Section 2332E4 to allow final appeals to the Supreme Court in governorship election matters. This was intended to provide a further judicial safeguard, allow correction of erroneous appellate decisions, because Court of Appeal decisions were going off in their different directions and didn't care what anybody said, and see strengthening public confidence in the electoral adjudication process. Now, the current procedure and the implications of the proposed reversal of 2010 amendments. As part of the current constitutional review exercise, a bill has been proposed, one, to return the Court of Appeal back to the final appellate court for governorship, National Assembly, and State Assembly matters. 2, remove the Supreme Court's jurisdiction in these matters, especially the resolution of governorship appeals, thereby reversing the 2010 reforms. And I have explained why this proposal is unreasonable and retrogressive. 1, as earlier shown above, the location of finality of governorship appeals at the Court of Appeal before it was amended led to numerous miscarriages of justice. There was no remedy even when palpable legal errors existed. 2, considering the economic, administrative, and security powers wielded by governors, it is only fitting that their emergence through elections should be subject to the highest judicial review. 3, making the Court of Appeal the final authority increases the risk of pressure. And nobody will say he doesn't know that there's pressure on judges in this era that we're in, or even before. Manipulation or inconsistent jurisprudence, especially in politically sensitive elections like gubernatorial elections. Removing the apex court from the appellate chain will stifle the development of uniform electoral jurisprudence, a very important point. In a polarized and volatile polity, Nigeria, electoral decisions should inspire trust. Only the Supreme Court provides the gravitas and finality required to instill intrinsic confidence in the system and avoid takeovers and state capture by ambitious political interest groups. I can assure you that the reason why Court of Appeal is being proposed is that some political forces now see that the Court of Appeal is a softer ground to engage in state capture, and then say that's the final court, there's nothing we can do. So the Supreme Court provides some level of confidence and trust in the entire system. The case for the Court of Appeal not to be the final authority on governorship and deputy governorship appeals is compelling, especially because of the invidious situation that took place in Plateau State, arising from the 2023 election, reveals significant concerns about the reliability of the Court of Appeal in such matters. Had it not been for the Supreme Court, which had the opportunity to examine the issues, the governorship election and our good friend, the governor, who would not have been there, would have likely faced the same fate as the House of Assembly and National Assembly petitions. What occurred in Plateau State in 2023 was a profound injustice, not only to our democracy, but to the electorate who turned out in large numbers to vote for their preferred candidates. The inconsistency in the application of the law undermines confidence in the judiciary and the electoral process. With respect, an amendment to the appellate jurisdiction of the Supreme Court is a call for a repeat of what happened in Plateau State and the disturbing situation before the second alteration of the Constitution. Now, I now refer to the Honorable Justice Agnew, GSC, in Manasseh against Kushi, citation provide, where he held. On the issue of nomination, this sought to be used to remove Muftwang as governor. The primary election and nomination of the appellant as a candidate of the fourth respondent for election of governor is a pre-election matter, and they use pre-election matters to remove half of the House of Assembly by the Court of Appeal. By virtue of Section 2859 of the 1999 Constitution, any firm action against such election or nomination must be brought to court within 14 days from the occurrence of the event, decision, or action complained of. As it is, the primary election and nomination of the appellant as fourth respondent's candidate occurred about 6 months before the petition was filed. The tribunal challenging it on ground 1 therein, contrary to Section 2859 of the 1999 Constitution. The petition is therefore statute barred and incompetent in ground 1. The tribunal lacked the jurisdiction to entertain and determine that ground of petition. In the light of the foregoing, I hold that the Court of Appeal wrongly overruled the decision of the tribunal that it had no jurisdiction to entertain and determine ground 1 of the petitions. The tribunal and consequently the Court of Appeal lacked the jurisdiction to determine it. Therefore, the tribunal rightly declined jurisdiction to entertain it. The exercise of jurisdiction by the Court of Appeal to determine it is a nullity. So at this point, consequently, it meant that those who had been removed by the Court of Appeal where they had finality, and the Supreme Court said, look, we can't interfere. The Constitution has already given them finality. But in a case that went to the Supreme Court adjudged what the Court of Appeal did in robbing the Plateau State House of Assembly of its legitimate and lawful members as a travesty. And so the Court of Appeal, being the final authority, increases the risk of pressure, manipulation, and inconsistent jurisprudence, especially in politically sensitive cases, elections like gubernatorial cases. So may the day never come where we will return in governorship cases to Supreme Court has not said they are tired. They have not said they are tired, and even if they are tired, they should resign and retire and go home. If you don't have the energy to do the work, leave it. But don't come and endanger a whole country and a whole state when additional safeguards have been provided for you to deal with it. What is the Court of Appeal? An intermediate appellate court. And they're saying go to a final court. That gives more room for judicial accountability. And so it can never be an issue that will succumb to in this country, unless they want there to be anarchy. Now, other judicial reforms in the current constitutional review process, the electoral justice system. The reforms are seeking for the creation, it's very laughable, of pre-election tribunals to ensure disputes regarding qualification, nomination, and internal party processes are resolved promptly before elections without overloading the regular courts. They are also proposing shortened timelines for resolving election petitions to guarantee that all litigation is concluded before elected officials are assume office, thereby preventing the destabilizing effect of post-inauguration nullifications. That will never happen in Nigeria. Let's just forget about it. Because it's the same people that will say justice delayed is justice denied, that will say justice rushed is justice crushed. So let us make up our mind and stay in one place. We don't have to mimic and copy other jurisdictions when we have something that is working for us. My position, because of our unique political culture, where political participants exhibit negative tendencies, such as A, winner-take-all approach, B, non-concession to opponents of clear electoral victory. C, the desperate desire to influence judicial outcomes. There is an imperative need to insulate the main judicial stream from pollution by politicians. That has always been my view. You give me, if I have my way, let politicians break their heads as they want. They should never involve the judiciary. We make money from it, I won't lie. But if we are thinking nationalistically and altruistically, these are political matters, let them resolve it. The politicians in America are more deadly than our politicians. Those ones carry gun in their pocket. They can do all sorts of things. But once a man has defeated you on the field, you clean your wounds and go and fight back next time. And our politicians will learn that. Some of the negative and indeed demonstrable injuries meted to the system include, but is not limited to, extensive delays in the resolution of regular cases in all the superior courts. For example, courts are beginning to make allowances in their diaries, as we speak now, for the political tsunami anticipated in 2026 through to 2028. I sent somebody to court the other day, and they were giving him 2030. 2030 in the Supreme Court. Because they blocked 2026 and 2027 for politicians. Pre-election and election petitions and other sundry political cases. So if you want to be SCN, go and look for go and look for such matters. Consequently, the most desirable constitutional amendment would have been to insulate all these courts identified in section 6565A to J, and they are here. They have put them, reproduced them in the footnote here. Totally and comprehensively from any political or electoral related cases. Politicians, for obvious reasons, have succeeded in irretrievably gaining the absolute attention of these courts for their own benefit and to the detriment of ordinary citizens and corporate citizens, or persons and corporate citizens. As things stand, it is estimated that across board, 75% of judicial time, and I use my own cases as empirical example, 75% of judicial time is expended by courts in resolving and adjudicating on civil, criminal, political and electoral matters relating to politicians and politically exposed persons. Let me just explain this. If you take my own list, whether defending an ex-governor, an ex-senator for a criminal allegation in court is part of the judicial time that is being taken. Pre-election cases is part of it. Election matters, that one you close shop for 1 year because you will do 180 days in the tribunal, 60 days in the Court of Appeal, and another 60 days in the Supreme Court. And imagine you have 2 or 3 of such matters. And there are off-season cases. So if you choose to be a good election petition lawyer, just remain there because that's the work you do until the day the Lord calls you. The only remedy is for, and this I have written a personal memo to the Attorney General of the Federation. I have raised it in so many places. I hope if people buy into it at this point, they will help us to transmit it. That is to insulate our courts, since politicians must always go to court and get judicial stamp of approval. And since we too must chop one way or the other. The only remedy is to create a court, a super court that will exist at trial, intermediate, and final appellate levels. I think, is it Abacha that tried to bring it? The Constitutional Court. It was during this civilian era. And the late Justice Dairo Mustafa was tipped as being the president of that court. Now all it means is this, that take out from the Federal High Court, the High Court of the FCT, the High Court of States, pre-election matters, fundamental human rights, make it concurrent to all the courts in the country. Election issues, let even political parties carry themselves to court. If you must open the door, open it fully, let people go and make a fool of themselves in court. And bring all those cases under the umbrella of the Constitutional Court, which will have the same powers as the High Court, as the Federal High Court, as being a superior court of justice. And create one in each state, let it have a minimum of at least 15 judges, and let the politicians carry all their wahala to it, to that court, so that business people, private individuals, people who are doing land cases, people who are doing cases of tort, people who are doing contractual matters, commercial law matters, can gain back the regular courts, which have now been invaded. The politicians are an invasive species of fishes. You know the name of that fish that invaded America? Snakehead fish. So give them their court. That's their pond. Let them play, wound themselves as they want there. Just like the National Industrial Court has sanitized the courts, and they took away employer-employee cases, labor cases, and even though the National Industrial Court beat too much, they took everything for themselves. As men, they took too. So that if you are doing any serious constitutional amendment, amend now so that we can have a court for broad politicians. Then if there is dissatisfaction with the decision of the Constitutional Court, let it go to an appellate Constitutional Court. And then when they finish with the appellate Constitutional Court, which will be on the same level as the Court of Appeal now, give them a further appeal. They have money. Give them a further appeal to a final Constitutional Court. No, don't let them touch these Supreme Court justice. Now you will be surprised. I'm sure if you create this thing, the allowed Supreme Court justices, Court of Appeal justices, and the Federal High Court justices to opt to move to this new court, you will be surprised that those courts will become empty. Why? I don't know. But give them an option that, okay, it's not that we are saying you'll only be doing battery, assault, shipping, mining, and it's so much jurisdiction, banking in Federal High Court. Go, if you like politicians, go and do their cases. So that is the tenor in which constitutional amendment should go, and not in trying to destroy the existing system by taking more than the 75% that you have already taken. Now let's look at the Supreme Court itself and proposed reforms. It is being requested that you expand the number of Supreme Court justices from the current limit to a higher figure to reflect caseload realities. Introduction of leave requirements before election and political appeals can reach the Supreme Court, ensuring that only appeals with significant constitutional or legal merit are entertained. Now, asking the court to increase beyond 21 is what an evidence of what is called see finish. The Supreme Court is now being looked on as a mega magistrate court. Where in the world has any Supreme Court had more than 15 justices? The America has 9. Somebody helped me with that of the UK. I don't think there are more than 12 there. Every Supreme Court around the whole world is a Supreme Court properly so called. And here is it, the politicians are now suggesting that you increase the number to 40. So everybody can bring his kinsman, his brother, to come and sit in the Supreme Court and lobby for cases for him to go his way when he's there. We must not allow our politicians to kill the system, because it's just an invitation to kill the system. Now I've said, the two constitutional proposals can be conveniently taken together. The full complement of Supreme Court is 21 justices. and I've dealt with what I've just said now, that an apex court, such as the Supreme Court, is a policy court. I never used to agree that it was a policy court, but nowadays I think I'm gravitating towards the fact that it is a policy court designed for the streamlining of law and justice through the determination of landmark/monumental cases, which will then set the stare decisis trajectory for other courts and cases to follow. A Supreme Court is not a magisterial division and should therefore not have a bloated bench. It is not the practice worldwide for any apex court to have such inflated number of justices as if it was a state high court, like Lagos State High Court that has almost 80 judges of the High Court. And at least each one has the control of his courtroom and gives his judgment separately. The best way to maintain the dignity and sanctity of the Supreme Court is to close some of its open-ended jurisdiction. And there is no better way to achieve this than by taking out of its jurisdiction to adjudicate on political and electoral cases and transferring them to the proposed constitutional courts, that is both trial and appellate. Please engage in the campaign of insulating the Supreme Court from political cases. In a polarized country like Nigeria, the requirement for leave to appeal as a means of sifting meritorious political cases is or will be a non-starter, as the court will be accused of favoring one group of cases over the other and will lead to accusations of bias and discrimination. That is exactly what will happen, thereby diminishing the apex court's judicial integrity. Justice must be equally available to all and sundry. The judiciary already suffers from reputational crisis, whether real, malicious, or imagined. Nothing should be done further by politicians to place the Supreme Court in such an unpleasant and indeed awkward position. And I'll consider the removal of judicial officers. It is being proposed that there should be a mandatory National Judicial Council investigations before the removal of heads of court, aligning same with the Supreme Court decision in CRESCENT and another. Indeed, I think it was More that wrote the review in CRESCENT against Habib for me, because I represented the NGC in that case. Citation provided. Now, there's no problem with section 292(1)(a)(1), because what they are proposing is already what is provided by the Constitution. And that is why Imo was not able to remove his chief judge. Anytime I could talk about Imo, his other just shakes her head. He couldn't remove and then tried to remove 18 judges all at once in anger. But at least 9 of them survived. Now, there is no need to further consider that provision, because the law as it stands today by the Constitution is that before a head of court or any judge or justice can be removed, the NJC must investigate the allegations against them. And that's why it did not work in Elelu Habib, it did not work in Ashadahiru CJ in Sokoto, it did not work in so many other cases in which the House of Assembly had tried on the governor's request to remove heads of courts. There's still one raging in Ekiti now. But nonetheless, the point is that that section should not be tampered with. If not, we'll come round and see that they have taken away even that which was in existence before. This proposal, as taught, will institutionalize fair hearing, that's if left at that, ensure due process, and insulate judicial officers from arbitrary removal. Now, I've dealt with my position let's go to the position of this, my position and the suggestion that NBA should have an input in the removal of judges. Being a former NBA president myself, I say that that is a non-starter. The NBA is a political organization through and through. And with this modern approach to things, it is getting increasingly difficult to find the NBA taking its position. In any case, the long and short is that it should not be entrusted with the removal of judges, because that goes against everything. The interested parties, one. Number two is that they are already members of the NJC. 5 members of the Nigerian bar are there who are nominated and confirmed by the National Executive Committee of the bar. So if they are there, why do you need to take the same matter to the NBA and they will do voice vote to say Justice XYZ has been removed? And it's a constitutional provision. So what the governors have failed to get from the House of Assembly, they want to humor the NBA to say, go and do voice vote and remove Chief Judge of Imo State for me. I beg my brothers, see me later in the evening. So it is not going to work. We know these things. The only remedy which I have been fighting for from when I was in NGC, and was in the NGC for 2 terms, is that legal practitioners should not be limited to the matter of appointments while sitting in NGC. The judges, I don't know whether it's pride, whether it is superiority complex, but never wanted lawyers to sit in council on disciplinary matters. The only time that people were fair to themselves was when lawyers were sitting in council, when Kennedy Shofola and the rest took part in discipline of judges. But I again got it set aside when doing Justice Senlong's case, to say no, they can only be there for appointment only. And I came back to complain that they should amend the constitution, which is the proper thing to do, and allow lawyers to sit fully in every matter of counsel. Now, mind you, there are 2 laymen in council who sit there for 5 years at first term, and that 5 years. Lawyers only stay there for 2 years. They simply don't want you to get used to the workings of NGC. So they say just keep bringing 5 every 2 years, 5 every 2 years. Now, the laymen stay there for 5 years and sit in discipline of judges that the lawyers are not allowed by those who they went to law school together with and those whom they practiced with merely because they chose to be in the bar to participate in. And I've always consistently fought against it. And I said, in that case, when it comes to the discipline of lawyers, the judges insist on sitting in the legal practitioners disciplinary committee because they say the statute allows them to sit. Amend the statute. Let lawyers too sit in the discipline of judges. We pass handover batting from lawyer to judge back to lawyer in the legal practitioners disciplinary committee. We have not boycotted LPDC because judges are sitting there. We take them as our brothers. So why do they not want lawyers to sit in NJC in the matter of discipline of judges? In England, most discipline of judges is done by laymen and lawyers. So I think there should be a shift in the mentality of, I can say this to them because not many of them are older than me in this profession. And we have all seen these things together. And when we sit down, we should be able to tell each other the truth. And the truth is that the National Assembly wants to amend, take out that proviso that says lawyers should only be sitting in the NJC only on issues of appointments alone. It is degrading. I pulled out of NJC because of that. They had to come and say, come back, we'll look into it. But they still didn't look into it. Specialized courts. Another proposal being made in the current exercise is the establishment of ecclesiastical courts of appeal to adjudicate Christian religious disputes in the FCT and willing states, like the Sharia courts of appeal in other states. There is no basis for state involvement in the upholding of religious beliefs or the adjudication of religious disputes through or with state-sponsored judicial mechanism. It is akin to the Sharia disputes that occurred, that occupied the rhetorics of the evolution of the present constitution. I can tell you for free that these provisions are just being put there so as to distract attention from dangerous other issues that we have pointed out to, so that more time will be spent on talking of religious issues while the greater damage is being done in other places. We know this country, we've been part of this system. There is no empirical evidence justifying the creation and existence of such courts as to warrant state intervention. It is a postulation that has divisive tendencies. The churches are there to decide disputes among their members. After all, the Holy Bible does not permit litigation or lawsuits among members. And in the footnote 6, I have referred to 1 Corinthians 6, 1-8, where Apostle Paul addresses the issue of lawsuits among believers. He urges the members of the Corinthian church to resolve their disputes within the church community rather than taking it to secular courts. So any right-thinking Christian will not externalize a dispute. So if politicians are saying we want to create court for Christians, it's self-serving. They want to politicize the church and use their pulpits. They are already doing it. Use their pulpits to collect, make them canvass for votes for them. But not at the extent of spoiling the relationship between believers. So it's an unnecessary proposal and should be discarded or jettisoned forthwith. Judicial continuity and stability. The proposal in this regard seeks to empower newly elevated judges to conclude part-hard criminal matters rather than starting afresh. You remember the case of Ojus or Kalu, where Mohammed Idris had been elevated to the Court of Appeal and later elevated to the Supreme Court within a short period. And he came back from the Court of Appeal to conclude a part-hard matter in the Federal High Court. This proposal, I say, ignores the practical realities and the injustice associated with a judge who has left the services of a court and has taken the oath of office of another court hierarchy to return to the court that he has been elevated from. I said, it is submitted that no amount of constitutional amendment will cure this abnormality and aberration. It's like using the constitutional amendment to declare that a man is now a woman. It will never work. Because once you leave a court, you have changed the nomenclature of who you are. And you cannot return to that court, even if constitutional amendments are not 100% foolproof. So, one didn't work. You remember the one that it's not even a constitutional amendment, I'll get to that, on local government autonomy. It has not worked up to now. So it is better to defer the swearing in of an appointed or promoted judge until when he has completed all his part-hard matters than to cause such a judicial personnel to return to a court that he has exited from. No one seems to consider the psyche of all the parties concerned. No matter how it is couched, the amendment will not work, and for a variety of reasons not relevant here, because we will bring them out when we challenge it in case it goes through, will be struck down at the earliest opportunity that the issue presents itself for adjudication. It is also being proposed that there should be transition safeguards, whatever that means, that ensure an orderly and merit-based succession plan for heads of courts, curbing political interference. This is another clear example of a situation where the legislature leaves its own functions and seeks to micromanage another arm of government, to which the judiciary, when the latter is a separate and indeed a distinct arm of government that can manage its own internal matters. This proposal is clearly overreaching and should be jettisoned at the earliest opportunity. The point being made is that members of the National Assembly and those making these proposals are either the disenchanted members of the judiciary or people who want to make an inroad into the judiciary. Anti-corruption and ethics. It is being proposed that in order to promote anti-corruption and the sustenance of the Code of Conduct and Ethics among judicial appointees, the membership of the Code of Conduct Tribunal be increased from 3 to 7 to reflect regional diversity and strengthen impartiality. This is not sufficient in the circumstances of Nigeria. It is mere tokenism. Apparently, it's the only one of the constitutional amendments that I agree with, but with the following adjustments. At the heart of our national problem is the attitudinal disposition of public officers and political appointees to matters of their code of conduct, ethics, and anti-corruption values. Everybody just pays lip service to this veritable check and potential block to the activities of corrupt officials. The reluctance and at times outright refusal by public officials to declare publicly and submit their asset declaration forms and other documents in compliance with the provisions of the Code of Conduct regulations is responsible for the high level of corruption in the public service of Nigeria. Any meaningful proposal for constitutional amendment in this direction must be such as established in each of the 36 states and the Federal Capital Territory. A Code of Conduct Tribunal, that means there must be, to be serious, every state must have a Code of Conduct Tribunal to facilitate the enforcement of the Code of Conduct provisions in the Constitution and our extant laws. That is why the proposals usually submitted by public officers and public office holders are such that render the system weak and ineffective, thereby slowing the entire process to be business as usual. Again, it is suggested that there should be a constitutional amendment that will institutionalize ethical training and disclosure provisions for judicial officers and tribunal members. Again, these are not matters for constitutional amendment. Rather, they are matters that can be asserted in the Code of Conduct Miscellaneous Provisions Act. A constitution is a very serious document that should lay out the basic and indeed fundamental rules for the governance of the country. It is not a factory manual on work and safety regulations. Our legislators should accord the Constitution more seriousness than they are presently doing. Federal High Court Electoral Offences Jurisdiction. It is also being proposed that the provisions in relation to the Federal High Court in the Constitution be amended to empower the court to cloth it with exclusive jurisdiction over violations of the Electoral Act and electoral offences, ensuring that politically favored cases are handled by a competent and impartial forum. Remember, the Federal High Court is almost becoming like their court now because they've taken over all the business. So they are not afraid of saying take our offenses when they say because familiarity breeds contempt. Take our offenses there before the Federal High Court. Now this is my response to it. Again, the politicians are not being serious with the basic problems of this country, which is rooted in all the crimes and shenanigans perpetrated by office-seeking politicians in the electioneering process. The answer to this conundrum has been provided since the year 2008 by the report of the late jurist, Justice M.L. Uwais, GCON, former Chief Justice of Nigeria, and his committee known as the Uwais Report. Politicians who benefit from electoral crimes will never implement the Uwais Report. Rather, they will continue to make absurd and indeed half-baked suggestions so as to obfuscate the real issues, thereby manipulating the system and coasting home to illicit victory at each election cycle. If the 10th National Assembly desire electoral reforms in its fullest ramification, they should simply legislate the Uwais Report into various acts of the National Assembly and stop deluding Nigerians of their good intention. Judicial resignation and succession protocol. It is also being proposed to have constitutional amendments that regulate resignation procedures for justices and judges to avoid abrupt and destabilizing departures and provide mandatory structured handover and protocols and record transfer mechanisms to aid institutional memory and continuity. Do you understand what this means? That if a judge wants to resign, they should provide them regulations and mechanisms so that his records will not be lost. There will be institutional mechanisms. Whatever that means. This is a typical example of institutional idleness. The National Assembly is idle. How can these transfer mechanisms, that means you are saying there should be a mechanism to transfer what a judge is doing. In the event of sudden death, when he attains 70 years old, or he is unable to work as a result of grave illness, or even sudden resignation because of certain personal issues, how can you legislate for that? What would you be saying? The worst is for the judge, unfortunately, to drop dead due to overwork and lack of provision of facilities and payment of his allowances for him. You won't pay the things that you need to pay him for him to be happy. You'll be saying you want to manage the way and manner he resigns. If they are not ready, I think there's too much money in this process of constitutional amendment, and everybody comes up with harebrained schemes. Such eventualities and their after effect cannot be regulated upon. You can't make a law as to when I want to resign and that I follow it. I want to go, I want to go. I'm not your slave. Or if the Lord calls the person, what do you want to do about it? What the proponents of this amendment lose sight of, the proposal, is that these courts are courts of record. And it's not the chief judge or any of the other judges or heads of court that is the record keeper. Their records are kept by the chief registrar and his coterie of registrars and clerks, who are civil servants and permanent features in the establishment. And if you need any of their records, apply for a certified true copy of the records. So what is the essence of now trying to amend the Constitution to put in some irrelevant provisions in it, tasking judges to do certain things, when indeed you have not paid them their pension, you have not paid them the things that they need to be paid to live a good life? Let's face serious things. These proposals lack any utilitarian value. They are now saying there's another proposal which is strange too, curtailing state chief judges' alleged power abuse. I don't know how many chief judges have been brought to the NJC for abuse of power. Other proposals being considered seek to introduce checks on the powers of state chief judges by strengthening the roles of judicial councils and peer review mechanism. And they seek to achieve this by promoting decentralized administrative structures within the state judiciary to reduce arbitrariness. Imagine they're now leaving their own assembly, going to micromanage the judiciary. And they have also made proposals to reduce over-concentration of powers in the office of the state chief judge. Listen, ensuring collective decision-making within the judiciary. I say this set of proposals are insipid and an attempt to create issues where there are none. Every organization is held accountable by and through the leader of that organization. The office of the chief judge of the state is not the target here. The targets are the offices of the president of the Court of Appeal and that of the Chief Justice of Nigeria, and by extension, the entire judiciary. Indeed, it strikes at the twin principles of independence of the judiciary and the separation of powers. Why should you interfere in how the judiciary is running itself when you recognize that there is independence of the judiciary? And you know there is separation of powers. What is your business as the legislature in finding out how a chief judge runs his court? What is good for the goose is good for the gander. Let the proponents of this amendment also promote an amendment to the powers of the Senate President and the Speaker of the House of Representatives, that in order for these offices to be stripped of their arbitrariness and over-concentration of powers, the work of the National Assembly, hitherto directed by the Senate President and the Speaker, should be executed by or through panels. Will he agree? He is suggesting that the chief judge should work before he gives a judge a set of books. He should set up a panel to do it. So will they agree in the Senate President or the Speaker? Whatever is not broken should not be fixed. These proposals should also be discountenanced. Now, we go to the structuring. I'll soon be through. These are just some of the key ones. To state the case for true and fiscal federalism. That is plain enough. We thought when this government came, they would approach the issue of fiscal and true federalism, but like I spent time in explaining that when you go out to capture power, you use epithets like there is no federalism, no true federalism. Once you take power, you go into command, take all. One line command. So this is still on the table, fiscal federalism. The governor of Kogi State, through the Honorable Attorney General, has mentioned that the powers vested in the central government is too vast, and that they should make some of the powers concurrent. And he cited mining, for example. You will be sitting in your state, mining licenses will be issued. People invade your state with strangers and militant elements and make a nuisance of your life thereafter. And so something has to be done, and these are one of the real ways of doing constitutional amendment. Now, this main one is the state police and security architecture. At the 13th webinar of the Rule of Law Development Foundation, I commented on the creation of state police. And I said, for now and until the political actors improve their political maturity, the alternative would be and should be community police. I propose most respectfully a measure where every ward in a local government should have an office of community police that will monitor and ensure the reportage of all crimes and the movement of all suspicious characters who may likely pose a threat to the peace and harmony of the community. Where the threat is beyond their capability, such is immediately escalated to the remaining wards and local government headquarters, control points, and to the state police command. All these funds being used to buy rice and other palliatives should be used to fund and equip security watch offices in those locations as described above. One point must not be lost here, which is that Nigeria is under-policed, and whether the intervention to ameliorate the problem is the introduction of a state police or community police, what is desired with the greatest urgency is the decentralization of the federal police outfit, that is, the Nigerian police force, so that the 36 states and even the federal capital territory can constitute, and note please, run its own police structure, by whatever name you want to call it. It is apparent, therefore apparent, that the constitutional monopoly of the federal government of Nigeria on internal policing has not yielded the desired result in curbing crime and inadequacy, insurgency. Consequently, there is an urgent need to decentralize the nation's security architecture. And I recommended an amendment of Section 214 of the Constitution to allow for the creation of state police with clear delineation of jurisdiction and accountability mechanisms, ensuring legal provisions for community policing, vigilante networks, local intelligence mechanism, i.e. hunters, that can work in collaboration with the federal and state forces. To establish a federal oversight body, this is very important, to standardize operations and prevent abuse of power by state actors, so that state/community police will enhance prompt response to local threats, promote accountability, and foster citizen cooperation in crime prevention. Now, there is one that I would leave for people to read on their own, which is on local government autonomy in Nigeria. I was briefed by the Attorney General to represent the 22nd defendant in the matter of Kogi State, and we know what our eyes saw in that case. Now the Supreme Court, I will take it, you know the history to judgment, then I will state the problem and what the solution is. The problem: although local governments are theoretically closer to the people and best placed to address grassroots issues, the control of their funds by state governments rendered them ineffective. Several local governments could not execute meaningful projects due to inadequate or non-existent funds. The result was a muffled third tier of government, with local government councils becoming administrative puppets of the states rather than autonomous developmental units. The hijack of local government funds was one of the core grievances that led the federal government to institute the suit by which it sought to enforce by litigation the financial autonomy of local governments and restrain state governments from interfering with funds meant for them. Irony and impracticability of the Supreme Court judgment, that is judgment of AGF against AG Abia State and 36 others or 35 others. While the Supreme Court's judgment was seen by some as a victory for local government autonomy, the reality remains that implementation is near impossible with the current constitutional structure. The court's pronouncement did not strike out the existence of the state joint local government account, meaning that states will still serve as conduits for fund disbursement. In practice, this makes the judgment difficult to enforce without further constitutional amendment. Moreover, it is not within the federal government's constitutional purview to dictate how local governments spend their funds, just as the state government should not dictate, and they have a greater right to say spend your funds this direction because they have the developmental master plan of the states. Doing so undermines federalism and the principle of separation of powers. Any attempt by the federal government to bypass states and deal directly with local governments is both practically and constitutionally irregular. Amendment rather than imposition. The current approach by the federal government, whether through executive fiat or directives, is not sustainable. In a democratic federation, reforms must be rooted in consensus and law, and not in force or strict judicial pronouncements. The more pragmatic and lawful solution will be to amend the Constitution to either abolish the state joint local government account entirely or guarantee direct allocation and accountability through better institutional mechanisms. Importantly, such a constitutional amendment would not only ensure direct allocation of funds to local governments from the federation account, but would also enhance transparency and accountability at the grassroots. With allocations coming directly to local government councils, they will be compelled to account for such funds more responsibly, thus fostering local development and democratic participation. Once the funds of local government gets to them, I can even go and contest for local government chairman to see that my people develop. In effect, the reform will move local governments from dependency to autonomy and accountability. Attempts by the federal government to unilaterally intervene or enforce control over local government funds have only aggravated tensions and led to more confusion, litigation, and resistance from states. While the concern about local government underdevelopment is valid, the path to fixing it lies not in coercion, as the Tinubu administration has sought to do, but in democratic reform, particularly constitutional amendment backed by the political will. The mission for genuine local government autonomy in Nigeria cannot be accomplished through litigation alone. While the Supreme Court's decision in AGF against AGIBS State was a bold affirmation of the principle of financial independence for local governments, it fell short of dismantling the constitutional devices, particularly the state joint local government account, that continue to undermine the autonomy in practice. But mind you, many local governments owe the state government's debts. So how will they pay? So that is, there's so many issues that they need to really sit down and consider over a long period of time, and not by judicial fiat. Without a constitutional amendment that guarantees direct allocation of funds to local governments and mandates transparent systems of accountability, the third tier of government will remain financially impotent and politically subservient to state governments. Reform must therefore move from rhetoric and judicial pronouncement to structured constitutional activism. A reform structure that ensures direct funding, enforces compliance, and demands accountability from local government councils will not only revive grassroots governance, but also strengthen the federal character of the Nigerian state. It is only through such democratic and institutional realignment that local governments can fulfill their constitutional mandate as instruments of development, inclusion, and responsive leadership at third-tier level. Finally, even though the above discourse applies strictly to financial autonomy, the same principles apply to other core areas of local government administration, such as dissolution of local government councils, generation of internal revenue, etc. Although the Supreme Court has decided in the case of Governor of Ekiti State against Olubumo that the arbitrary dissolution of elected local government councils is unconstitutional, there is an urgent need to amend the Constitution to reflect the purport of this decision. In addition to the amendments suggested above, it is recommended that Section 7 of the Constitution be amended to guarantee full political and financial autonomy to local governments. Mandate direct allocation of funds from the federation account to local government accounts without blockage or interference from state governments. And 3, prohibit the use of caretaker committees, ensuring only democratically elected councils run local governments, except, of course, in situations of extreme unforeseen emergency. Creation of new states and constitutional amendment. I'm sure a lot of people will not like me after hearing my views on this. News floating around indicate that 46 states are recommended for creation. The proposal for state creation, with profound respect, is the most unreasonable of all the proposals for amendment of the Constitution. The reasons are not far-fetched, and allowing this brazen political agenda to proceed unabated appears to be the greatest breach of faith committed by the present administration. Firstly, the APC government promised during campaign for the 2023 general elections a gravitation to true fiscal federalism. Thus, in the minds of reasonable Nigerians, this administration will encourage a debate among well-meaning Nigerians as to how to reduce the size of government, enthrone true democracy, and set out plans to shrink the states and collapse them into more manageable number, such as 6 or 8 regions or states. Secondly, it is a known secret that at least 2/3 of the 36 states are not financially viable or buoyant, and most are in economic terms bankrupt. But for the Tinubu economic reforms, a number of them will not have been able to raise much needed internally generated revenue, which they now deploy to meet their budgetary requirements, as the FAC allocations are usually used to pay off foreign and local debts. In financial terms, therefore, it is not viable to embark on the creation of new states for now. The demonstration of the unreasonableness of the demand for creation of additional states can be viewed from 2 angles. The first being that Nigeria is just about the size of the state of Texas in the United States. But if Texas was an independent nation, it will rank as the 8th largest in the world. In 2024, its nominal gross domestic product amounted to $2.7 trillion. On the contrary, Nigeria's gross domestic product per capita is a mere $327.3 billion, ranking it in GDP terms as one of the lowest in the world. But Nigeria in general economic ranking is number 32 in the world. It's still far away with our claim of being the giant of Africa. Now Texas, though ranked 8th in the world, has only one governor, one bicameral legislature, and one judiciary. Nigeria, on the other hand, with peanuts of the kind of money that Texas has one huge federal executive, president, vice president, National Assembly made up of the Senate and House of Representatives, the Supreme Court, the judiciary made up of the Supreme Court, Court of Appeal, Federal High Court, National Industrial Court, many tribunals and courts, etc. Ministers, permanent secretaries, Millennium Development Agencies, special advisors, and many others that benefit from just these 300. Not the budget is not 327 billion; it's the GDP. As it relates to the states, there are also 36 governors because there are 36 states. One powerful FCT minister, 36 houses, 36 houses of assembly, 36 judiciaries, and countless agencies and parastatals. What Texas is managing to do with one line of command and structure, we are doing with about 120, and we pay salaries, allowances, buy chips, and aircrafts and the rest of them for these officials. So why won't the country, people say they are hungry? But if we reduce it to 8, 6, have 6 governments, at least we are making progress. Now they want to increase it to 46. They are plus 37. So when you add that together, you will now get about how many governors? And they will all build government houses, and the people will be poorer. Yet, these present politicians want to engage in the creation of new states or entities that, based on the above, have no business being created or being referred to as states. Now, let me, and I beg my Southeast Zone friends not to think I'm being personal. The other reason which has been given, I saw my friend Senator Mwaboy canvassing on AIT that the Southeast is marginalized and they need additional states to balance with other places that were regions just like the Southeast. So this is my analysis. There is no marginalization. When states were created in 1967, the Eastern region was balkanized into 3 states. The East Central State, the Cross River State, and the River State. But successive exercises is being claimed has not been fair to them, and they need now 4 more states. This request is based on misguided postulations. The entire Eastern region now has 9 states, and I've listed them: Anambra, Abia, Akwa Ibom, Bayelsa, Cross River, Ebonyi, Enugu, Imo, and Rivers. While the Western region has 6 states: Lagos, Ogun, Oyo, Osun, Ondo, and Ekiti. And the Midwest region have 2 states, Delta and Edo, totaling 17 states. And the Northern region, which has a larger landmass, has 19 states. The claim for marginalization from the foregoing statistics simply falls flat on the state. If its central state was 1 state out of the 12, take the ratio. And today they are now 5 states, and they have been fair. 1 state to 5, Western region to 6, and you will have time to respond. So there is no unfairness. Where do you want to divide again? Look at the land mass. So, well, it is therefore, that's why the debate is on. In other case, states are not created based on perceived marginalization, but on the strength of several strong factors, the most important of which is viability in economic terms. Based on the weak economical ground that the nation presently stands, what should be the agenda of state creation is the transmutation of the 36 states to 6 institutionalized geopolitical zones. That is what every patriotic Nigerian should back. If not, let's all go away on our own path and form our country. If you like, create 1 million states within your country and see whether it will survive. Conclusion. Nigeria's constitutional amendment process presents a rare opportunity to correct foundational defects in governance, justice, and institutional accountability. While reforms like state policing, devolution, and local government autonomy are crucial, special attention must be paid to judicial reform, not only to protect judicial independence, but to improve the quality and credibility of electoral and criminal justice. Removing the Supreme Court from final appellate jurisdiction in gubernatorial and legislative elections is a retrogressive step that should be resisted. Instead, reforms should prioritize judicial efficiency, merit-based case filtering, and systematic safeguards without compromising the right of appeal to the apex court in high-stakes dispute. The National Assembly must therefore ensure that constitutional amendments align with democratic best practices, historical lessons, and the urgent need for public trust in Nigeria's legal system. Finally, it must be noted that it is not the hood that makes the monk. Constitutional amendments do not guarantee an efficacious system. If the Nigerian elite are to be honest to themselves, they will readily agree that the reason for bad governance and corruption in Nigeria is not the nature of the constitution in use, but the attitude of the leaders and those at the helm of authority to the basic principles of governance. I've always believed that a constitution is not what determines how a country is run. It is the honesty, the decency, the God-fearingness of the leaders that will determine. You can apply any constitution if you are equitable and fair. But if you want to use the constitution to amass power, of course there's no way you'll be fair, there's no way there will be justice, and there's no way there will be peace. The question to ask is whether our leaders subscribe to basic principles such as the rule of law, separation of powers, free and fair elections, and anti-corruption goals and targets. Do they subscribe to this? Let them ask themselves. I know they have no conscience, but let them ask themselves whether they subscribe to this. So long as we cannot conclude that they do, and then even if we amend or replace the Constitution 1 million times, it will all end up being a futile exercise. Thank you for listening or reading.
Thank you very much, very learned Silk. You can all agree that the learned Silk dealt with his paper eloquently. He went in depth into talking about the problems of modern day Nigeria. He spoke about issues in our judicial process, which includes but not limited to overloading our regular courts with political matters. He has preferred a solution of creating special courts that will deal with election matters from start to finish. Hopefully these suggestions will be carried out to aid speedy dispensation of justice. He also is very passionate about state policing and the importance of community policing. He has proposed decentralization of the federal police so that the 36 states can run their own police structure. At this point, please allow me to recognize the presence of a member of the Board of Trustees of the Rule of Law Development Foundation and the Managing Partner, JB DAUDU & Co., Mr. Adedeji Adedayo. Please also allow me to recognize the presence of a member of the House, Mr. Ben DAUDU. Without further ado, we'll go to the next item on the agenda, which is discussion by participants online and on-site. We would like to start by calling one of our own, who is like family to the House, no other person but Justice Alaba Ajile, to give just a contribution on the topic. Thank you very much, sir.
Thank you very much, Mr. MC. Let me say that I stand on, as it is usually said, that I stand on the existing protocol. In doing this, I want to acknowledge and congratulate the celebrant, Mr. JP, Senior Advocate of Nigeria, for delivering such an erudite paper. The delivery was eloquent, and he was very down to earth in the points that he discussed. And well, reviewing such a distinguished paper surely is a very formidable task for me. The paper has been very informative. We have got to know so much about so many things within a short time. It has been very insightful and has been very scholarly in the paper. It was very honest. He didn't hide his feelings, and I think he deserves to be congratulated even for delivering that paper. Can we just give a round of applause? I am not surprised. I've known him for a very long time. I've been part of the Rule of Law Foundation, and I can testify to his dedication and expertise, which I would say has propelled him to the pinnacle of his profession. And from his bio data now, that we know he made the silk, becoming the youngest senior advocate of Nigeria in his time, at just 15 years at the bar. I think we once again need to congratulate him on that. We have had him, and he has said so much. The paper covered, I think, about 5 or 6 areas of constitutional amendment, and judiciary bill, so many of them he reviews, pending before the National Assembly, creation of 46 additional states, national. I think it must have increased to 48 now, because I think day before yesterday, it came out that the Senate has passed a bill approving the creation of additional 12 states. So, local government autonomy, state police, and other constitutional alteration proposals. Well, he expressed his views, which no doubt very strong, and which he is also very entitled to. And but I am sure it will not be in all the points that he raised that many of us will agree with him, with due respect. And I can see my sister, I'm sure he's waiting to take the mic from me now, when he says something about the creation of states. Yes. And with due respect, really, I want to disagree with the learned Singh on the factors. Maybe consider the creation of states. In Nigeria, within historical context, what we know in the past years, over creation of states, I think one factor that can be said to be very potent and will remain recurring up to today is the marginalization issue. You know, states clamor for creation of states is usually anchored on marginalization issue. And but Lanesik tried to maybe diminish that factor. And I'm sure that's why my sister was, I don't know it's my mind, but probably that could be. But surely it is not an aspect that one can ignore. In fact, it is usually the first factor. We are marginalized, we want to be on our own, we want to, and things like that. All right, so now, Lanesik started his paper considering the usual noise being made about the Constitution being, in fact, we hear that the Constitution tells lies against itself. You know, it is a statement that we hear almost every day. But Lanesik has disagreed with that it is not the process of the Constitution that confers legitimacy. It is not it's not the process by which a Constitution is made that confers legitimacy, if I understand it well. But, you know, the acceptability of the people that confers legitimacy to God. Honestly, 100%, I agree with him. And today, I am hearing from him, maybe for the first time, because more noise is on the fact that our Constitution is not autonomous, that they have just imposed the Constitution on us. But it's another perspective now, that a very thoughtful one, that Lanesik has taken, that it's not about how the Constitution was made, the process it has been, but the fact that what about the people? Have they accepted that this is their Constitution? And we have been operating this. Sorry. So he made that very valid point. He makes the point the process of amending Constitution should be a serious matter. In his own view, it is like we just we take the amendment of Constitution as a joke. And we know serious matters that ought to propel amendment of Constitution. You know, in most cases, they are not found in most of the processes that we have witnessed. Because amendment of a Constitution ordinarily should refer the changes, you know, and address contemporary issues. You know, but what do we have today? He has listed so many areas in which attempts have been made to amend the Constitution, which may not necessarily be in line with what amendment should be. He draws attention to the onerous nature of the process of amending Constitution. But I want to remark here that as onerous and as difficult as the process might be, the way he has presented, we have had about 5 alterations. You know, until this dispensation, people didn't really know that Constitution could easily be amended. And under the political dispensation we have now, we have never seen a state be created. And you hear people too, who are against creation of state, telling you it will not be possible. From the experience of amendment of Constitution now, I want to believe that there is nothing that is impossible. States can be created. Before now, I still hear people saying only the military can create states. But if the Constitution can be amended in the way they have amended in the past, for the past years, having 5 alterations, I don't think that it is impossible to amend the Constitution. Just few other remarks that I want to make about from the paper, very erudite paper of Lanesik. Election petitions terminating at the Court of Appeal. In total, I want to agree with his submissions. You know, of course, we have the Constitution, we have creation of state, we have the hierarchy of courts. To deny people from exercising their rights to the highest court, I think will be a way of not allowing the constitution, the courts, to be accountable even for them. Because he cited the example of Plateau State, and I'm sure up to today, many people agree that the legislators in the Plateau State House of Assembly, they suffered injustice. And he didn't mince words in describing those things. So I want to agree with him that yes, most of these election petitions, particularly the governorship, should really end in the Supreme Court. And of course, he also derided the process whereby in 2010 we all cried, let this thing go to Supreme Court. In 2025, we are saying, let the process, let it come back to the Court of Appeal. So I agree with him on that. The Supreme Court, the reforms of the Supreme Court. Well, ordinarily, one would have thought that one basic solution to the problems we have in the Supreme Court, sadly, one heard from him that cases now being adjourned to 2030. We are in 2025. Ordinarily, the natural thing would be maybe the workload is too heavy for but he has come out with a very intelligent answer to the problem. The issue is not increasing the number of justices. That is his position. It's not increasing the number of justices, but looking at the type of cases that should be going to that court could be a way by which we can reduce the workload of the Supreme Court. And he said there's no better way to achieve this standard than by taking out his jurisdiction to adjudicate on political and electoral cases. And on this line, he has also suggested a parallel court system, the constitutional court system, where you have an equivalence of the High Court, in terms of a constitutional, maybe High Court, a constitutional Court of Appeal, and a constitutional Supreme Court, that will be exclusively concerned about political and election cases. And honestly, I pray that thoughts will be given into that to see what will happen. Then judicial continuity and stability. It is his view that it is better to defer the swearing in of an appointed or promoted judge until he has completed all his part-time cases, instead of trying to taking any attempt to amend the Constitution along that line. Why not? Okay, he's entitled to be appointed. He has been appointed, but you still have some cases urgent cases that you need to attend to. Why not sit down and work on before you go, before being sworn in? But after wearing the toga, after wearing the dignity of a justice of the Court of Appeal, now you will come back and become, as you are sitting now, in what capacity? Are you sitting as a justice of the Court of Appeal, or you are sitting as a judge of the High Court? It is incongruous, and I think that point was clearly made. Anti-corruption and ethics. For constitutional amendment in this direction must be such that each of he focuses on code of conduct tribunal, and his own suggestion is the issue is not just increasing the number from 3 to 7 membership of that court, but rather, in fact, that corruption is so pervading that even if you have such tribunals in each of the states, they will get busy. So, and you made a very strong point that a constitution is a very serious document. that should lay out the basic and indeed fundamental rules. The issue of powers of the chief judges, he said, and I want to agree with him, nobody has complained to the National Assembly that chief judges are overbearing, chief judges are. So what is their business? He gave the reason. The target is not against chief judges of the state as such, but the targets of the National Assembly are directed to the President of the Court of Appeal and the Chief Justice of Nigeria. Creation of state police. Yes, the addition I want to put or inject into his paper in this respect is to request that excesses of there should be means of controlling the excesses of the governors too. You know, governors, we know who they are. We know how they, with due respect, they abuse powers. And if eventually this state police, you know, is created, they will just, of course, their political opponents will become prey, victims in their hands. So the need for, if state police will be created, the National Assembly should go a step further to find a way of saying that the governors, you know, do not abuse the power, you know, in respect of the of those state police. And finally, that is a matter that is of interest to me. Really, is this local government autonomy, and it really amazes me to see that the Supreme Court will deliver a judgment, clear judgment on a matter of such significance, constitutional significance. And yet, it will appear that the Supreme Court is impotent in implementing his own decision. So, which way out in this matter? Leonard Singh gave some insight into it, what should be done and what should not be done. But he also recommends that it is not just about courts giving judgment, and I agree with him. There are issues that can be dealt with instead of concentrating, looking for how to curtail the powers of the chief judges now. You know, why can't you look into the area of this implementation of local government? And he has recommended that this can be achieved through constitutional amendment. And of course, this joint state judges account up till today is still part of the Constitution. And of course, you cannot ask the state governors not to build the Constitution. So it's like there is even a contradiction in this matter now. As you are saying, in one way, with due respect, as you are saying in your judgment that, okay, this money should go straight to the local government, you have left a very fundamental provision of the Constitution that says, when this money comes, let it go to this joint account where they will sit down. So, Leonard Singh has recommended that if anything could be done, before anything could be done, he does not see any way anything can be done in this way until that provision is brought down. And I agree with me. So, on the whole, once again, I want to commend the heredity of the Leonard Singh. I want to commend his forthrightness. I want to commend the hard work he has brought in. And I pray it will not just be, this program will not just be a talk show. We should proceed from this point to see how those that are involved, you know, particularly the legislators, should know about it. Maybe some of us, we will take it to our representatives, some of these things. And I want to thank everyone for listening. Congratulations once again. God bless you.
Thank you very much, my Lord, for that robust intervention. Next, we would like to call on DC Ewelum, Senior Advocate of Nigeria, for his intervention.
Good afternoon, everybody. I will stand on the existing protocol already established. This webinar series 14 is principally in celebration of Malene Senior in every respect. It is a celebration of his 45 years as a lawyer and 30 years as a senior advocate of Nigeria. So I do believe it is proper for me to join in celebrating him because I've known him for 35 years plus. We were worshiping in the same church. We were worshiping in the same church, Holy Family Catholic Church, Baranawa. In fact, every Saturday evening, there are 3 of us. We will go and wale him to ensure that he, as he was coming out from confession, we will stop him and say, "Can you tell us what you..." Then Paul and Benedict were just, yes. But seriously, I know he's very, very committed to his church. I'm speaking now like Gospel of St. Luke, chapter 1, verses 1 to 4. That in as much as many have undertaken a full narrative of the things that have happened amongst us, just as they were delivered to us by those who from the beginning were ministers and accepted of the words, it seems good to me also, having followed all things closely, to write an orderly account, that you may know the truth concerning the things of which we have been informed. I am now saying my own account that you may know the truth about JBWSL. In Kaduna Bar then, he was, before he became the leader of the bar, he was out to see that every lawyer following him behind made progress. I think my learned brother K in the here will bear me witness. He will call you and say, when he came down to Abuja, come, go and you see this Abuja where they look at, now better market. Just set up your shop, day, don't worry. As you drive away flies, one day, better thing will begin coming. So he was encouraging everybody to make progress. SANs, if about 10 or more SANs from Kaduna were influenced by him, I'm very honest. He is somebody that some evenings he will call me, Dan, where are you? I will say, come. If I say no, say, Dan, leave everything you are doing, come now. I will go, we will sit down, and we will be cracking jokes and all that. But in the process, he kept on telling me, Dan, apply for this thing now. Dan, apply for this thing now. But let me confess, I think I've told this story before. I'm an Igbo man, and there's a saying in Igbo land, your nobility starts from your home. Your nobility should start from your home, not from outside, back home. So I now told him, I only have, that was 2004 when he started telling me to apply. I said, I only have a 3-bedroom house in my village. And if you don't have a duplex, nobody cares, even if you're a professor or Chief Justice of Nigeria, nobody reckons with you. You say, damn, leave that thing. I got a saying when I was a tenant. I will say, okay, but when I got to him, I say, this man is not an Igbo man. He doesn't understand what he's saying. By the time I found nobility in my village, the years have so much passed. But even at that, he was still encouraging. So I want to pay that tribute to him for being somebody that cares for his friends and those around him. Thank you very much, JB. I won't call you the other one. Even now, there are so many lawyers that know that there's this saying, no hunter that kills an elephant takes the whole meat is a lie. When you kill an elephant, you have to call your fellow hunters, the villagers to come and share because only you cannot. I think that is his principle. Briefs, he will say, come and join me. That way, a lot of lawyers have made progress, have grown as a result of his large-heartedness. I also want to thank you very much. Now to the topic of today. Let me also make a light-hearted discussion. When I was briefed by the Attorney General of the Federation then to handle Federal Republic of Nigeria versus Abacha, I was part of it, High Court, Court of Appeal, Supreme Court, and they called me to handle it, handed over the record of appeal and the brief, and I saw J.B. DAUDU. I slowed down. My confession is that I booked for mass and I started going for morning masses. Even on the day we went to Supreme Court, I was at John Paul. I went for morning mass that day. When I finished, I gained my confidence. I went to court. When I saw this, I had no opportunity. When they said I could make a remark today, there was no opportunity for me to attend any morning mass. But I will make my few comments, knowing that JB covers the field, like the former Attorney General of Kogi State said when we were doing the VAT case at the Supreme Court. After JB, we said, JB gets the job done. Let's just sit down here. I said, no, me, I will do my own. He said, JB has done the job. So, in the words of Ablaye Haruna, former AG of Kogi State, JB has done the job. There's nothing to add to his paper. What I will do is to just make one or two observations. And the first is on the issue of this amendment. I thought of it the first day that SAN asked me to come in. I said, yes, I would like to attend, principally because the way we take amendment to the Constitution is just like house rules in the assemblies, House of Assembly, Senate, House of Reps. Somebody wakes up and says, Mr. Speaker, I want this rule, and they will send it to the relevant committee and it will be amended. Constitution is far more sacred, far more solemn, that it does not cater for how I wake up and start my car and go to court. Constitution is so solemn and sacred, it does not have to cover how I relate with colleagues and so on. And therefore, my opinion on that, on the entire effort at amendment. What we have today, 5 amendments have been made, and most of these amendments are from 2010 to date. What have we achieved? We can't be amending and amending for the sake of amendment, and most of these sections of the Constitution that have been amended are things we should have left. Worse still, in sorry. Yes. In 2, they said the National Assembly has a right to increase or reduce the jurisdiction of the Supreme Court. I don't find that very comfortable. Again, the section 233 of the Constitution, of the same Constitution, on the jurisdiction of the Supreme Court and the jurisdiction in civil and criminal cases. They say in civil or criminal matters, in civil or criminal matters, any appeals. Well, one they say in law, it's a right of appeal, but in civil cases, you seek leave. But my opinion is that we cannot leave the jurisdiction of the Supreme Court to any appeals whatsoever. If we agree, like he has done in his main paper, that the Supreme Court is a court of policy. Please, I don't understand the policy in rent tribunals getting to the Supreme Court. I don't understand the policy in traffic offenses or traffic matters getting to the Supreme Court. Even I don't understand the policy in I disagree with my wife and she sues me to court. It gets to the Supreme Court. If we agree Supreme Court is a court of policy, we should have that at the back of our mind and leave the Supreme Court with very few issues that touch, one, on the existence of Nigeria, two, on the relationship of states and the federal. That is enough. It is more than enough. Like, I agree with him again. He knows I don't disagree with him except on one point. He said it earlier on. So I can never disagree with him because I know how deep and wide he is in his research. So I agree with him also. Most of this, we rather create constitutional courts to take off this election, all of them, all the election matters. But even at that, in particular, rather than tinker with increasing the jurisdiction, let us reduce it. And in practical terms, the average age with which you get to Supreme Court is about 58, and I'm being generous. Most of them get there 62, 63, 64, 65. I think me and, let me talk about those I know. Me and Kehinde here, we understand what it means to be in your 60s. I don't know about others, but we understand what it means to be in the 60s. And if you're at that age, for goodness sake, you walk from, you sit in court from morning till maybe 1, 2, go retire to chambers to write judgments. That is why 5 years in the Supreme Court, you start going for a medical, yes, one hospital or the other. And you remember an ex-Chief Justice of Nigeria that fell out with his fellow colleagues because he couldn't provide the medical bills for people to travel abroad and get themselves treated. It is bad that, one, the age of the judges at the Supreme Court, and two, to burden them. They are, even if you get 45-year-old like Dio SAM here, I am very sure that within 5 years he will be in the Supreme Court, he will start having one element or the other. So, rather than increase the jurisdiction, we should reduce it drastically. Two, Court of Appeal also, some of those cases that get to them should also be reduced. The average age of getting to Court of Appeal is about 45, 50. How many of them are that healthy to be engaged? Now, this vacation, they would have selected judges and say, go and clear backlog on ad hoc. Go to this division, go to this division, go to this division. I think we should be encouraging some of our judges to be healthy and well, so that this issue of setting judgments and then congested docket can be reduced. Thank you very much. Once again, I congratulate my Oga. In private, you know.
Thank you very much, Mr. D.C. Ewelum, Senior Advocate of Nigeria. Before we open the floor for goodwill messages, we'll call on Mrs. Ozioma Izuora to give her intervention. Thank you very much.
Thank you so much, everybody. I've already had a lot to say on JB DAUDU SAN, and he knows that many times I make it a habit of not agreeing with him on certain issues because everybody else will tend to agree with him. I'm looking in all of this that you picked out, SAN, and I do not see anything touching on those gender bills that are in the court. Are you afraid of what we will do? Are you afraid of expressing an opinion that will get you for? Because you should have commented on it. It would be good to hear your mind on their viability. For instance, I do not agree that 110 seats should be created, especially for women, because I do not understand how that's going to work. But I do believe that there should be some kind of affirmative action to increase the number of women in the National Assembly so that poor Natasha will not have to be afraid of expressing herself when she feels she's been badly treated. And look at your SP running around trying to appeal against common sense, more or less. Okay, I pointed that out because it's not here, and you need to, sir, have an opinion on the gender bills. Please, let's be directed. They're not all good, so say so. Please, take that boldness. We need that. Please, I can't come out here and praise you today on being caring for everybody and for you not to care about us actually. Now, actually, on the structure of Nigeria, the zones, you know, my LLM was constitutional human rights law. So these were the things that we played with all over the place. The place you made a mistake, sir, is in stating that Southeast is not marginalized. It is marginalized because the new structure you're looking at are 6 zones. And each of those 6 zones has to have an equal number of states. It makes sense. It is equity. I'm not saying, I mean, and if you do increase some, now by what they are demanding, all this creation of states, some, the northern states are also asking for extra states. Oh, they feel marginalized. And remember, on that part about 12 states, you know, that the thing that Gowon did to make the minorities happy was also, like you properly said, was to malign the East because there were figures there that they wanted to water down their powers by making river states people, including Wike, say they're not Igbos or anything like that, you know, as if they abandoned property. All of those things resulted from that creation of the state to try and whittle down the power of a few Easterners. So now, forget what came before or after. What we're looking at now are 6 zones with 5 of them having 6 states and 1 having 5. There's no equity in that. That's my position, sir. The other part is on religion, the right to, under Section 38, I think, to religion, and Section 10 that says we're a secular state. They're saying now, oh, put ecclesiastic. It's a reaction against the fact that we have Sharia all over the place. So, sir, if you're saying, don't put, and I'm not, please don't misunderstand me, saying create ecclesiastical code, that's just not making sense. I don't want to say bad words in front of cameras, but I'm asking, should we not do something about actually making the constitution, making Nigeria secular? Why do we have Sharia all over the place? Sharia is from the Islamic law. It can handle itself, can it not? Can we not create a system that caters to Sharia without putting it in the constitution? Because that is what is building the anger, that is making people say, put us in there too, we're part of the country. There is right to religion. Let us remove this. Let secularity be secular. And all of that. What was the other thing I had? I really, today, I'm not agreeing with you on a lot of things. I'm not. I'm just saying, please reflect on the things that women are asking. Tell us which ones should go forward and which ones we should step back on. Please don't be scared. Will not hurt you. And thank you. It's always an honor to be given an opportunity. Oh, okay, all right. Thank you.
Thank you. I think there's still a room for goodwill message, so I don't combine the two. Okay. No, I want to take goodwill message separately. Thank you, the next sir. I think this is my first physical participation on the Rule of Law Foundation. And I really enjoyed it. I must also confess that I'm highly enriched, sir, for being part of this. These areas that bothers me, sir, like my sister has pointed out, is this issue of creation of states, sir. I totally agree with the views of NESEC on the basis that it is not how many states we have, assuming that this issue of this idea when one is trying to come up as a president or leader of the, he's talking about true federalism. If this is actually implemented in this country, we discover that there's no need for states, creation of many states. It's because there's no true federalism. That's why we are clamoring for more states. If things were properly managed in this country and states as they are managed, there's no need for more states. I agree with Lindsay to that extent. But sir, where I am worried is where you listed the Eastern region with 9 states, thereby bringing in Akwa Ibom, Bayelsa as part of Eastern states. I'm worried on that because these are south as they may be. And sir, when you come down to your conclusion on that way, you now advocated for 6 institutionalized geopolitical zones. And Akwa Ibom, by virtue of that conclusion, is not part of Southeast in the 6th zone we are talking about, sir. God bless you, sir. Thank you, sir. And this is the second time I'm hearing that suggestion. The first time I heard it was when Dr. Elias Ekwemele, our former vice president, was having his birthday or whatever. He gave it as a birthday, took it to Nigeria, that we should have 6 geopolitical zones as states so that we can develop this country. And that will take away all this agitation of having creating more states. So I really enjoyed that and I totally subscribe for that, to that position, sir. Then, sir, what area I want you to clarify me, which appeared to be a bit confusing, is that you recommended removing Supreme Court from appellate jurisdiction in gubernatorial and the legislative elections. Okay, the opposite. Then you recommended we having a constitutional court, which is perfect, sir. So if we have constitutional court as trial and appellate court, do we still need to go Supreme Court? Thank you, sir. I need to get that clarified. Then, sir, finally, from our angle or what, we have not pushed forward, even as MBA, the implementation of YS report. What is wrong with it? It's overdue. I thought that the bar, by now, should have hold on to that. But the bar appears to be weak on that, especially at national level, sir. We are at the lower level. I want to talk. So, sir, I think you need to do more work there, sir. Let's speak from there. Maybe they will hear us, sir. Thank you very much, sir.
Thank you very much for your answer.
My Lord, the distinguished Leonard Silk, the celebrant, Leonard Silks, distinguished guests, ladies and gentlemen, I take the opportunity to stand on existing protocols. Where I come from, when we have juggernauts and people who are very senior to us, it's a bit difficult for us to sit down and address people who are way. Yes. So I do crave the indulgence of the House to stand when I give my comments. I think I would start personally regarding who I understand the celebrant to be. When we all start off as young lawyers, those whose reputation precede us, that we have heard in the newspapers, stand as titans before us, and there's this hesitation to even get close or even try to interact with individuals of that sort. I would say personally that The Leonard Silk is the first individual of that category that I encountered that had a character that made me feel very, very normal in his presence. It was like talking to somebody who you've known, for all your life. There was no difficulty in his relationship with us. He basically didn't know who we were, but he had this very, very receptive personality where you felt very comfortable and you felt you could discuss anything on earth with. And I believe that character has been a disposition that he must have always had. And that has spanned over time. And he has maintained that character up till today. Today we feel very comfortable in the Leonard Silk's presence. He's somebody that, in spite of his stature and standing, you feel as if you are relating with a friend. It is a very, very rare quality, and it is something that we admire. We believe that that comes from a well of very deep wisdom and from somebody who God has laid hand on. It's a very, very difficult personality to attain if you do not have some kind of divine guidance and you do not predispose yourself to the ways of the Lord. So there are ways you manifest how the Lord works in your life, and your ability to relate with people is one of those. I think the celebrant is an epitome of that character. So we celebrate you personally. We can't just limit our celebration of you to the heights you have attained in the profession. We also have to celebrate you personally as a person who we look up to, who has the disposition and character that we would all wish to emulate. It's a privilege to be standing before you with the kind of the position that you are celebrating in terms of your years at the bar and the story that we have learned from you regarding your elevation to the inner bar. It is an example that I think we should all emulate. It comes from very, very hard work. There's no time that you would meet the Leonard Silk in court that you wouldn't learn something in particular. There's always something you will take away. For some of us who the law has been a passion, there's a tendency to believe that the amount of hard work you put into it would be the height of whatever it is you would learn. But you find out that if you encounter the celebrant in court, it won't matter whatever it is you have learned, no matter how well prepared you are. There's something that you would gain from the Leonard Silk in that particular encounter. There's a matter in which the Leonard Silk leads us currently. And in spite of the fact that I had been up to 15 years at the bar, I changed my tactics of cross-examination based on, how I witnessed him handle cross-examination in that matter. And it has entirely transformed the amount of work I can deliver in the courtroom regarding what I had learned from the Leonard Silk at that particular encounter. So I will continue to encourage that for as many as can either be in court and see the Leonard Silk do his job, because I believe that whatever challenges we have in the profession, one of the ways we can improve that is through training. And the way we learned it, because I started my practice in Lagos and Benin, one of the things that was the practice and tradition in those jurisdictions was that the most senior lawyers called their cases out of turn, and the most junior lawyers would remain in court and observe and at least take their case last. What that did for us was that each of the seniors that we watched their cases had something from whom we could learn. So if you have the opportunity to be in court where the Leonard Silk is practicing his stuff or is conducting his case, both appellate cases, both trial cases, there's always something to learn. And I think colleagues should take that approach to improving themselves in this practice. It's an easier way to become a better lawyer, who you watch and how you pick from the person that you're watching. That said, may I move to the comments that I'll have regarding this very, very erudite paper. I would say that having regard to the reputation of the Leonard Silk, This paper does the usual justice to any particular topic the celebrant takes. And anybody who goes through this, at least, will be challenged with perspectives that will be difficult to contradict. But that being said, I would like to view whatever comments that I may make as mere contributions of my own perspective that should just be considered to see what can be made of it. I have 2 points that interest me. That has to do with the amendments as relates to the judiciary and state creation. Now, I would have to be forthcoming regarding my interest in state creation. I'm from Benue State, and I come from the group that are known as the Idomas. So you'd find that if you encounter an Idoma person, there's a general predisposition that they would probably want state creation. But that being put forward, I believe that whatever views I have there can be considered on their merits, notwithstanding whatever my personal sentiments may be. But I think I'll deal with that of the judiciary first. I would give a bit of background. Human beings, as well, whoever it is we operate on the basis of preset rules. If you are a family, we all know that you would have invited members of your family to give a particular kind of attitude in their relationship with the outside world. This normally happens, maybe the head of the house will probably invite people and, generally give regular precepts. So you find out that members of a particular family have certain expectations about how they behave. And that takes into account quite a number of things. This can be easily codified as either the convention of that particular family or any particular group. Now, I give this background because there's this tendency to believe that the Constitution is nothing more than a mere document. That all that it needs is that people should operate it, in a proper manner, and everything would be okay. It goes beyond that. The rules by which you operate determine the output that can come out of any particular system that you're operating, and the Constitution is one of those documents. So whatever is in our Constitution is intrinsic to whatever output that you're seeing from Nigeria today. It may require that we set up consultants to give it more study to understand its nuances, but we should not fall for the temptation to believe that the way you see Nigeria today merely requires people to operate our Constitution properly and everything will be okay. For those of us who were able to, had sociology as one of our electives, you would find that power, as we were told, inherently corrupts. Some of the philosophers that were mentioned by the Leonard Silk in those articles, if you read their work, one of the primary attitudes that is ingrained in human nature is that we human beings can't handle power responsibly. It's not one of the characters of human beings. So if you have a system that concentrates power, whatever the problem with power is, as the way humans handle it, will be emphasized and be magnified. So we currently run an executive system of government, and I can assure you, almost 99% of whatever problems Nigeria has today arises from the fact that we run an executive system of government. Because what government does is that it creates overregulation, it creates intervention within the society, and humans operate best, when you concede to them the right of their independent action. Of course, you have people who would not do things the way they're supposed to be done, but you have policing to deal with that. But you must devolve power and allow people to contribute their own quota. And I believe that the executive system of government inhibits that kind of approach. That is why it is not a mistake that our problems have exacerbated with military rule and with a system of government that concentrates power even more than whatever problems we seem to encounter during the parliamentary system. whatever problems we felt that the nation was facing during the parliamentary system has been emphasized even more, because if you concentrate power, the worst of your attitudes will be magnified. So that is what is going on. So I think the first step of what we need to consider as a nation, if it is possible for us to do so, is to consider stepping back from the executive system of government that we're running to something that is parliamentary. Now, one of the advantages that would have, particularly with respect to the kind of amendments we're considering, because a lot of these amendments are basically ad hoc. You adopt a particular system, it throws up certain challenges, and you now try to take ad hoc steps to deal with the new problems that have arisen. So why do we have a problem with appeals going to the Supreme Court regarding governorship and the president? We only have that kind of problem because we're running a presidential system. If you have a parliamentary system, these issues will be dealt with at the level of minor units. Because if you want to go into parliament, you go to your constituency, which are normally going to be very small units that don't carry, that don't reflect the entire nation. So you wouldn't have a situation whereby if a court is considering the election of a government official, that whatever outcome it has will be affecting the sovereign expression of political votes by constituents. So we need to go back to that system so that if we're going to have a prime minister, those issues will be localized in parliament. And it's not justiciable. It's who is going to be the prime minister shouldn't be a matter that should go to court. And we can even have a system where whoever is going to be president doesn't even need to be elected. We can have some kind of rotational arrangement where preset positions can automatically fill in the position of the president. But I believe that the parliamentary system would, in one fell swoop, solve a lot of the challenges that we're having. Now, if we're going to retain the current system, where courts are going to be dealing with these matters, because I'm not exactly a fan of the idea of the constitutional court. Even if we're going to have a constitutional court, the purpose of the constitutional court should not be to determine who is our representative. There are other constitutional matters which a constitutional court can handle. It doesn't have to be political questions. Political questions should be resolved within parliament and should be resolved locally. So there shouldn't be any element of our election system that goes beyond the ward. So if you're going to have INEC should merely be a regulatory institution where it prescribes rules that local election bodies would implement. So we shouldn't have an INEC that is determining who is our governor, who is our elected representatives, who is going to be our president. We don't need any of that. The local unit should determine that. And we should have a system where we allow the judiciary at the local level to deal with those questions. Election should be a local issue. Who represents us should be a local issue. If we're a nation, we should have a parliament that reflects that nationhood. And who governs us should be determined within parliament. These are not supposed to be matters that should go to court or should be resolved beyond parliament. Political issues should be resolved politically. And as the Leonard Silk had observed, the expression of political power can hardly be contained. We attempted to try to get the judiciary to litigate and adjudicate these issues, and we see what we have at our hands right now. We now have a situation whereby we have to have tribunals where we draw judges that are ordinarily supposed to be handling civil matters, and they are away for 180 days. We constrain our Court of Appeal for the same period of time, and the Supreme Court as well. So we don't need any of that. Political power should be constrained. We need to constrain political power, allow the citizens of this country to express themselves. If you have parliament, government will automatically reduce in size. The reason why we have a large footprint of our finances in relation to government is mainly because of the system of government we're running. You have presidential systems even down to the local government level. So we don't need, I don't believe that we need all that, and that doesn't contribute to how efficient any nation is run. You don't run a nation efficiently merely because of the presidential system. The efficiency of government in any society has to do with the culture and convention within the nation. If you go to China, the reason why the government is efficient is not because they are running a dictatorial system. It's mainly because of the convention and culture and attitude of the Chinese. Same thing with England. Same thing with the United States. They have a culture, convention, and attitude that is brought into behavior in public service. And without something like that, and it's difficult to have that in a country like Nigeria, where what you're dealing with is a nation of almost 450 ethnic groups, which particular culture is going to be representative of the whole. So we must have a very give and take attitude. And the only system of government that can engender give and take right now as humans is a parliamentary system. Any give and any winner takes all arrangement cannot work in a country where you are dealing with 450 ethnic groups. So that is what I have to say with regards to constitutional amendment as it relates to the judiciary, and I'm not one of the people that believes that the courts can effectively deal with political adjudication, whether in a constitutional court or in a regular court. So these things should be devolved down to the local level, where they shouldn't go beyond the level of a constituency. So with regards to state creation, I think my understanding of it stems from my personal understanding of it because of the state I belong to. So you have a situation where you have a population of people approaching almost, I think, 1.5 million or 1.7 million people. And this group of people, no matter their size, there are many states that are not even up to that number. But because of the constitutional arrangement in a particular state, that 1.7 million people are categorized as less than 1/3 of the state. And in a presidential system, you can't expect the majority not to dictate the tone of whatever arrangement. That's how the constitution works. So you can't begrudge the constitutional system in Benue State marginalizing a particular group, the Idomas, for instance, because they are less than 1/3. So unless you have a criteria that can enable Nigerians decide what the borders of their state are, you can't avoid the clamor for state creation. It's not possible, because there are certain groups that, even because of their size alone, are entitled to not be marginalized the way the Idomas are being marginalized. So state creation, I think, is necessary. I don't agree with the argument that it's going to increase the cost. The cost ordinarily should go to the citizens. And if state creation will make it more equitable, the politicians would have to live with that. I think the way out of the financial issue is for states to be more productive, or work out a system where Nigerians are more productive. Government steps back from the economic system and allow Nigerians to produce and have less regulations, so that we can actually have more resources in the country. But you must have a balanced arrangement that enables all Nigerians to contribute. And one of the ways to achieve that would be by way of state creation. And I think that you can do it in two ways. Either create states, or you work out an arrangement where entities are allowed to go by way of referendum to agree on what the borders of their states would be. So those are my humble contributions. Thank you, sir.
Thank you very much, Mr. Audu Anuga, Senior Advocate of Nigeria.
May I, with respect, adopt the protocol that has been efficiently established in the course of these proceedings. First of all, may I congratulate our leader, J.B. DAUDU, Senior Advocate of Nigeria. There is this popular saying that you are not a success except you have successors behind you. And there are some of us who are his constant lieutenants. Constant lieutenants. You are one of them. Mustafa Esen is one of them. You are also one of them. So many of us. Anozie Emenai. And I can see some of my Oga's old classmates from secondary school days. They are always around him. That shows the character of the person we are celebrating today. He is a man that is so accommodating. He has such a large heart. I've given my own side of the story of how, by the grace of God and with his prompting, I became a senior advocate of Nigeria 12 years ago. It was a single human factor that propelled me. And I think we should give him a clap. I went to him, I said, I still remember the statement I made that day. I said, okay, I'm tired swimming at the shallow end of the river. He said, what do I mean? I said, I want to get into the inner bar. And he told me exactly how to go about it. How many of your cases have you done? Where are your briefs? Each time I write a brief, I will take the brief to him. He will take his time and said, this sort of language is not befitting of somebody that wants to come to the inner bar. He will underline, and it was so meticulous. He was so intentional about me. And I'm sure a number of other people can have that same testimony. He's a man who is not afraid of having people joining him in the inner bar. We know some seniors that will do everything under the sun to ensure that you don't come to the inner bar. But that's not the testimony of our guy. So we celebrate you most profoundly, most immensely, from the depths of our hearts. And we hope very, very soon we'll have an opportunity to really pour out our hearts and our feelings about you. You are a rare gem. We thank you so much, sir.
Thank you, Mr. A.T. Kende, Senior Advocate of Nigeria.
Thank you so much. Just a comment about the paper. just one statement. Just one statement. I don't have the bias. I don't have the capacity to review my gas papers. Okay. About the constitutional democracy that we are practicing in this country. Somebody said, and I agree with the person, that since 1999, we have not, our electoral process has been degenerating since 1999. And that is simply because the umpire, INEC, that is mandated to conduct our elections, has refused to be responsible. That is it. They'll just tell you, okay, if you are not satisfied, go to court. The same system has put so much roadblocks that you can hardly get any justice. So we must have a rejig, we must have a rethink on how we will make that institution more responsive to Nigerians. Because INEC is being run by the taxpayers' money. And I think the major way or the major means of bringing that to bear is the process of appointment of the INEC chairman. INEC is not independent. He who pays the piper dictates the tune. We must have a way of insulating the appointment of the INEC chairman from the executive, from the political class. And that is, I don't know how we are going to do it, but we must sit. But I don't know how we are going to do it, but we must find a way around it. We must find a way around it. Otherwise, we'll just be going around the circles. We'll just be going around the circles, and things will be degenerating more and more. So, on this note, I want to congratulate my Oga once again. There are so many other things I would have touched, but the other speakers before me have spoken very eloquently about them. The creation of new states is a no-go area. A number of the states are bankrupt. They are bankrupt. If you create an Idoma state today, Igede will rise up and say they want their own state. So. The Ogoja people will not allow you. They will see you as somebody who is interlopers. So I think what we need to do is that as Nigerians, Obama won an election in the United States of America. As Nigerians, we must first of all think about humanity. This year, senior advocate of Nigeria, you are from the southeast. I'm from the southwest. But humanity is one. You are my brother. So why must I not be free to own a piece of land in the southeast and live there? When I'm tired, I move to the north central. Do you understand? We must start thinking Nigeria first, and that's the only way. Otherwise, we will continue to degenerate, and our youths are becoming really disillusioned. In our younger days, we all lived in Kaduna as brothers and sisters. But now, with all my imperfections. Thank you so very much. MC, thank you.
Thank you very much, sir. Thank you very much, sir. We shall give room for our participants online to give their goodwill messages as well. Mr. Adiola Adedipe, Senior Advocate of Nigeria, to give his goodwill message.
Good afternoon, sir. Good afternoon, everybody. The protocols have been established, so I'll write on the protocols. First, let me congratulate you, sir, for this milestone. The milestones are always coming. Someone like me, I've been privileged to work closely with you. And I use you as a compass in my office. Tell my colleagues first, when you are drafting a notice of appeal, and you have more than 4, 5 particulars, you are going into the realm of polemics. It's becoming an argument. Say, oh, God taught me this. I recall one time there was a judgment at the Federal High Court in the Dazuki's case. He was not a party to the suit, but the judge made a lot of far-reaching findings against him. Convicted. So we sat. I said, oh God, let's ask for leave. He said, why? I said, well, it was not a party to the suit. He said, think. It was not a party to the suit, but his rights had been impacted. His rights had been affected. Constitutionally, he should have a right of appeal. I argued with him. When we filed the brief, he appealed as of right. When we got to the Court of Appeal, Mr. EFCC Tahir, he filed an objection, resonating my point. So he said, no, don't worry. At the end of the day, the Court of Appeal agreed with Oga. No. In as much as you had impacted on his right, you had affected his right, in Section 241, you have a right of appeal. And that became the judgment of the court. I said, wow. Series of times I will come to him. He will not be quick to volunteer an opinion. Say, what do you think? So you must be a thinking factor around him. So I thank you, sir. And in as much as we try all the time to be like you, it's becoming it's becoming increasingly difficult. But we'll persist. And that's one thing about Ogatu. He has been consistent. All true. When I came to the bar, we started hearing about him. When I had the opportunity to work closely with him, consistency. When you go to meet him, he's always working. And I tell my colleagues in the office, because some of them one time say, oh God, you are still writing briefs. So you go to see Oga Egbarekpa, you will be working. Who am I not to be working? So we are taking so much coordinates for who you are, from who you are, and thank you for being a shining light. Thank you for providing guidance at all times. Thank you for the privilege of access. This morning I had come to him with a paper. I said, okay, I want to see you tomorrow. He said, no, don't come tomorrow, come on Sunday. You know, so those are the ways you have also been able to you know, grow. And I recall when I was about applying for, you know, to come into the INABA, and I put him as one of my referees. He wrote a very fine recommendation for me. But before he did that, I go bring the cases we did together. I won't just write for you. You know, I will draw inspirations from those cases. I thank you so much, sir, for the encouragement. Thank you for providing me the opportunity today. Wish you many more beautiful years in the INABA, many more beautiful years of, you know, leading us, holding our hands in this journey, the legal profession. Thank you so much.
Thank you very much, Mr. Adiola Adedipe, Senior Advocate of Nigeria. Shall be calling on Professor Benedicta Daudu to give her goodwill message.
Good afternoon, learned silks that are here, my lords, my colleagues, I greet you all. I'm here to celebrate the man of the moment at whose instance we're here this afternoon. A lot has been said about him. He has, in his submission, he actually talked about the state of the nation. And this is not the first time that Chief J.B. Daudu is talking about his worries, really, as it were, about issues of Nigeria. And it all boils down to issue of leadership, the kinds of leaders that we have. It's no longer a matter of the political will of our leaders. No, I think it has to do with attitudinal change. I guess that is what we really need. And that can only bring about good governance. Because over the years, we have people who have governed us, and all they just do is think about themselves, selfish interest. Now that I am a senator, now that I am a minister, what can I acquire for myself? You know, material acquisition. And that is the bane of corruption that we have. So, he has said a lot of things that should really keep us thinking. Chief Daudu, a lot has been said about him, and they're not just paying lip service to him. It is the truth about him. He is an enigma. He's a mentor, a role model, and a ray of hope for the rest of us. We cannot celebrate him enough. We just thank God for his life. We thank God for him, his leadership style. A lot of people have passed through him in his chamber, and he has affected lives positively, and is still affecting more lives. And we continue to thank God for this star that God has blessed us with. So I join others to celebrate you, sir. I join others to congratulate you. And my prayer is that God will continue to sustain you, and grant you soundness of body and mind to be able to continue to contribute more to the development of our society. Thank you very much.
Thank you very much, Professor Benedicta. I understand we have someone online, Mr. Christopher Oshomeke, Senior Advocate of Nigeria. Oshomeke, I'm so sorry for the pronunciation. Please, sir, if you can hear us.
You hearing me? Can you hear me now?
Yes, we can hear you, sir.
Okay. I stand on the existing protocol already established in celebrating our leader and our mentor, the great J.B. DAUDU SAN. It gives me a great pleasure to be part of this event. I greet you, sir. In all ramifications, you are worthy of all honors. A lot has been spoken about you, your humanity, your selflessness, magnanimity, and care. There's not much to add, but those are factual situations. In celebrating you, sir, I will take you back to about 2010. That was our first time of meeting physically in the year of your presidency. When you came to Kano, I was then the acting state chairman of the NBA. And my leader, you wanted to speak about yourself. I said, you don't need to say anything because we are following your trajectory. A lot has been spoken about you today, but one thing, apart from your prodigy as a judicial colossus, is your courage. Your courage to do the undoable. To dare that which other people run away from. I greet you, sir. Now, when I look at you, you are a beacon to those who want to be anything in this profession. Today, I had a lot of our colleagues saying you presented a paper. I know you did not present a paper. What you have presented is a compendium. A compendium that tasks the mind and challenge the brain. You went to intellectual excursions about our nationality. And that is your very self. Those who don't know you, who have not cared to know about you, my leader, you don't take chances when you come to intellectual engagement. When you come to speaking truth to the power. In your days as NBA president, I don't want to name things you did, but a lot of the things we are doing today were as a result of your action, and you are still fighting on. I will have been there physically, as always, I've been as part of this noble family. But circumstances make it impossible. But then, I'm listening attentively. And the beginning of your presentation of this great compendium is to establish the fact that a constitution is a bone and not the flesh. The day when constitution begin to deal with rat and rabbits, it ceases to be a constitution. A constitution ceases to be a constitution when it becomes a pot para, an all-common affair. That is the first thing you establish. The compendium you have presented today is such that it cannot easily be analyzed. It will take a lot of deepness to unravel that you have presented today. And I will say this with all respect that most of the things you have said, I totally agree. There are things that have known my mind also. And you have in-depthness around them, providing solution and showing alternative. We owe you gratitude for the work you are doing of humanity. As always, you have looked at the whole thing, and you talk about the problems of what you think is affecting our state of being. And in profiling constitutional court, you probably made a statement also, showing what may be the likely weakness or the effect. In the course of your presentation, how do you say that when such courts are created today, a lot of people migrate there? Well, I know that in continuation of your service to all of us, we still provide another solution. But every other thing you said, I totally agree. Because it looks anomalous that if some years ago we decided to say that this gubernatorial election should go to the Supreme Court, now we want to do a reversal. It doesn't make sense when there's no reason for it. Now, I fully agree with you. You look at the judgment of the Supreme Court regarding the local government and the implementation thereof, and you kind of show what in Latin Mazin is called a state of impossibility. Let's not cogit ad impossibilia. That is the truth. And we should not engage in fruitful plan. And you provide solution as it should be. I totally agree. The issue about the local government, with due respect, my learned leader, you know you are a prodigy, and I will ally with you, but I'm equally make a little comment. The issue of our local government and what they are facing today is equally a matter of self-denial as to what is a federal state of governance. If we want to create a Nigerian version, an autonomous one, let us be intentional about it. But you look a little bit a departure from the political knowledge and constitutionality about what federal state is. We'll talk of local government, talk of state, we talk of the federal government itself. This creates a little kind of hiccups and debacles, which we need to work on. The only thing I want to say, because this your compendium has encompassed nearly everything, there's an area I want my leader to pay attention to, because you have exhausted the others. I want, as a proposition, my leader, I think section 4, subsection 1 should be looked at. I submit with all respect and in vehement manner that we don't need a bicameral legislature. We don't need it. We need a unicameral legislature. And when I mean by that, because I've heard others even suggesting that the Senate should be abolished, I hold the other view. The House of Reps should be abolished. When you abolish the House of Reps, you now have only the Senate with equality of state, with fairness.
Sorry, sir, you have 2 more minutes.
The number may be increased to 5, 10 senators per state, but the idea of this bogus thing called bicameral legislation is inimical to our existence. We don't need it. All we need is a unicameral legislature with only the Senate. That is my own contribution. I celebrate you as always, and I thank God for you, and God will continue to give you the grace, the goodness of faith, to continue to lead us as you have done. Thank you so much.
Thank you very much, sir.
Thank you very much, sir. You and I celebrate you. Thank you.
Finally, we have one more intervention. Taye Agbaniyaka, if you are.
Hello, can you hear me?
Yes, we can hear you, sir. You have 2
Good
minutes.
afternoon. Yes.
Thank you, sir.
Good afternoon, everyone. My name is Isaac Taye Agbaniyaka, airline captain, Boeing 777 pilot, and I'm just calling to appreciate and also to celebrate my old school, high school classmate, Mr. J.B. DAUDU, Senior Advocate of Nigeria. There's a saying that goes that if you find a diligent man, high-stake performance, high-stake sacrifice will not be found far from him. And I want to just appreciate again and celebrate Mr. J.B. DAUDU, SAN, for his immense contribution towards the development of our nation, for his love for our nation, his love for humanity, his kind heart, his open heart, and his warmness towards everyone in a way that he's always striving to lift people up and bring out the best in people. My friend and my brother, may the Lord continue to uphold you and bless you with good health, with peace, with joy, and satisfy all your inner needs that even you may not know about. I thank you for all you do for Nigerians. God bless you.
Thank you very much, sir. Thank you.
I would like to recognize the presence of Abubakar Mustafa, SAN. You're welcome, sir. In the spirit of congratulatory messages and well wishes, I would like to call on the managing partner, J.B. DAUDU and Co., to give his congratulatory message on behalf of the firm and closing remarks. A round of applause, please.
The coordinator of the Rule of Law Development Foundation, our own J.B. DAUDU, SAN, Leonard Silks present here, distinguished participants, members of the Fourth Estate, distinguished ladies and gentlemen. On behalf of my colleagues, we want to congratulate you, sir, for this milestone. It has indeed been a great experience working with you over the years, and we are not surprised about all what we've heard about you today. We, over the years, have had first-hand experience of having to work with you. Your guidance, your inner access to listen to us and to guide us and to mentor us. We are grateful to you. As a matter of fact, we cannot thank you enough. We cannot thank you enough. There's really nothing we can give you but than just to appreciate you and pray that the Almighty God will continue to be with you, that the Almighty God will continue to guide you and grant you all your heart desires in good health and in sound mind. On behalf of my colleagues, we have brought this token. It's just a token as to mark the celebration of today, which is your 45 years as a legal practitioner and 30 years in the INABA. Ladies and gentlemen, I think he deserves another round of applause. I'm not good in singing, but please, I crave your indulgence to join me in singing the popular song of "For He's a Jolly Good Fellow, for He's a Jolly Good Fellow, for He's a Jolly Good Fellow." And so say all of us, and so say all of us, and so say all of us, for He's a jolly good fellow, for He's a jolly good fellow, for he's a jolly good fellow. And say all of us. Hooray! Hip, hip, hip! Yes, thank you very much. And
we implore us all to wait for pictures right after the closing prayer. Right after the closing prayer, but we have to take the closing remarks first.
Yes. Sorry, please. Having done that, may I, on behalf of the coordinator of the rule of law, to thank everyone for finding out time to come here today to participate in the 14th webinar of the Rule of Law Development Foundation in celebration of the coordinator's 45 years as a legal practitioner and 30 years in the inner bar. We indeed appreciate your time. Indeed, it has been a very robust interaction this afternoon, and you all agree with me that we have all learned one or two things from his world of experience and his thoughts on an issue which I consider a very, very topical issue that deals with our coexistence as a country. Once again, I thank you all for coming. God bless the Federal Republic of Nigeria, and may the rule of law continue to triumph. Thank you all for coming once again.
I'd like to call on Aisha to Isa for closing prayer. Right after, we'll have refreshments. Kindly bear with us for a delay, and pictures, please, right after the closing prayer. Please do well to wait around. It won't take long. Thank you.
Ya Allah, we thank you for a successful event. May the Almighty continue to grant our father and mentor good health and good life, and may the knowledge we've all gotten today be effective in all our lives. May Allah bless us, may Allah take us home safely and bring us back home safely.
In Jesus' name, amen.
Thank you. Pictures, please.
For the cutting of cake, we'll have all the senior advocates of Nigeria first.
Congratulations, sir. Congratulations, sir. Congratulations.
Classmates of the celebrant. Classmates of the celebrant for pictures.
Congratulations, sir. Congratulations. 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 Congratulations.
All classmates of the celebrants, please make your way to the front.
Congratulations. 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 We love you.
JB DAUDU and co-members of staff, get ready.
Congratulations. Congratulations.
JB DAUDU and co-members of staff.
It's a celebration. It's a celebration.